Don't mention any matter. I'll be in circuit for the next 2 weeks. So after that, I'll take.
Only for infusion, my lord, of a.
That is what we are saying. Come after. Yes. Next. So call others.
Item number 1.
You mentioned?
May I please, Your
Yes, you said. Was it appearing as to you mentioned?
My lord, this isn't, my lord, it has a quite lengthy, little lengthy background, my lord. There has been 6 applications, out of which, my lord, one application is not found. And there is a detailed office note. I also inspected the record.
One correction was made, but without the direction of the Lajima court.
There was a
There's an application for restoration, but
restoration was filed, but it was not. From my inspection, I revealed that the matter was never
not dismissed for default.
not dismissed. Well, in the case status also, it reveals that it shows that it is not dismissed.
Yes, so therefore that application will dismiss as
that has to be dismissed at
infractuous.
withdrawn.
But the condonation application is also pending.
Condonation application is pending, but the condonation application perhaps is not in the record, my lord. It is Can 1 of 1999. Old Can 8342 of 1999. That I may I suggest for it for
Yes.
supplying the copy so that can be treated on part of the record, my lord.
Can
Because that is in 99 now after
Can what means?
26 years, my lord.
And what about this? An application for substitution was there.
2 applications of substitution. One is one is
No, Can 4814. The initial one.
48.
Lajima court 10th of June.
4814 substitution application.
Directed the defect to be cured, but did not direct the office department to amend the cause title. Defect to be cured means the substitution was allowed by the
substitution perhaps within the time, and then it was allowed.
Note করে দেবে
addition of party was.
There is an addition of party application.
No addition. One is
10 20 to 10.
Rate with order 1 rule 10 2 করেছে
এটা একটা অ্যাপ্লিকেশন নেসেসারি অর্ডার সলিসিটেড বলেছিল
ডিপার্টমেন্ট থেকে
হ্যাঁ ডিপার্টমেন্ট থেকে ইন টাইমে রয়েছে অ্যাপ্লিকেশন এবার সেটাতে দেখি অর্ডার কিওর দ্য ডিফেক্ট করতে বলেছিল সাবস্টিটিউশন অ্যাপ্লিকেশন ভুল ছিল
ডিফেক্টটা কি সেটা
ডিফেক্ট ছিল সাবস্টিটিউশন অ্যাপ্লিকেশনে কিওর অ্যাড্রেস ভুল ছিল এবার সেটাকে কিওর করতে বলেছে ডিপার্টমেন্ট নিজের পার্টিদের যাদের সাবস্টিটিউট করতে তাদের নাম করে দিয়েছে সেটাকে রেজ করেছে হ্যাভ ইউ কারেক্টেড দ্য কজ টাইটেল অফ দ্য সাবস্টিটিউশন অ্যাপ্লিকেশন the substitution application 10th of June 2011 there was a direction by the Lajima court to rectify the defects in the address. Please go through this order. The learned advocate on record for the appellant is directed to rectify the addresses as given in the connected substitution application in terms of the order of the Lajima court dated June 10, 2011. During the course of the day, course of the office shall trace out Can 1 of 1999 and file a further report in that regard. Full let the matter be placed in the list under the same heading. Next, calendar ঠিক করে দিন রোজ এক জিনিস
এদিকে আছে এদিকটাও আছে
on May 11, 2026. Carry out the correction in the addresses. See the 10th June report of the Lajima Court registered administrator.
in the department or my lord hearing now, my lord in the department or hearing now, my lord. May I
Here.
Hearing.
Next.
Item number
In this matter, my lord, I appear for the respondent.
Yes.
My lord, this matter was heard on 2nd April 2026, my lord.
Right.
Then, my lord, the oral argument was concluded as recorded.
You wanted to add
Then,
something?
my lord, here, my lord, my submission, my lord, is this, my lord, there is a point of law is involved, my lord. That is skipped even from the
You have put it in your written notes of arguments.
Yes, my lord, my notes of argument, my lord, ready, but it is yet to be corrected, my lord. So I will make it, my lord, correction, and I can file it today itself.
Very well. So what is the additional argument you have
My
added?
lord, additional argument is there.
Make
my
that
lord.
argument so that Mr. Court can
They
make it.
they are relying on the section. They are relying, my lord, the section 80 of the, my lord, this right to fair compensation and transparency act in acquisition and rehabilitation settlement, claiming interest for delayed payment. My lord, that provision is not applicable. My lord, here the land was acquired, my lord, under the metro construction of metro. The Metro Railway Construction of Works Act 1978, and here, my lord, this act, my lord, 105 provides only the schedule 1, 2, 3 of the schedule 4th. 4th means, my lord, 13 companies, 13 acts are included, my lord, wherein Metro Act is one of them. There, my lord, the benefit will be schedule 1, 2, and 3 only. One is that.
But there's a notification. I will forward that notification to my learned friend. Let him consider and then file his written notes. Because, my lord, there has been subsequent inclusion of this provision in the Metro Railways Act. I'll forward that notification.
Although the matter was fixed for filing of written notes of arguments, learned counsel for the respondent submits that he had omitted to argue a point at the time of hearing, which learned counsel submits that the 2013 Act is not included within the scheduled acts which are applicable to an acquisition for the metro railway authorities. Which of next para, learned senior counsel appearing for the appellant submits that by virtue of a subsequent notification, comma, which will be forwarded to the learned advocate for the respondents by today, comma, by tomorrow, we are keeping it tomorrow, by tomorrow, comma, the 2013 Act has also been incorporated. Which of next para, accordingly, the matter is adjourned and shall next be listed on May 4, 2026 under the same heading for the purpose of incorporating, for the purpose of filing revised written notes of arguments incorporating the arguments made today.
Much obliged.
item number
Mr. Mitro, sorry, you do what you. The difficulties today, the regular bench is not sitting.
Oh, I've got the specially fixed matter.
It's specially fixed undoubtedly, but since
But
Justice
this one,
Bhattacharya
I
is
don't
not
know.
there,
Let's take it
if
later
it's a lengthy argument, no. If it's a lengthy argument, then we don't want to keep it parted before this bench because Justice Choudhury and I may not. I mean, we'll have to assemble again for that.
I
only.
see. I don't know which one.
That is the difficulty.
Then
So if
give
it's a very
me
short point, then we can hear it.
if
Otherwise,
you can to give us the next date.
it will be in the list. I returned from my circuit on 30th. 30th is a Thursday. We are keeping it on 30th of April.
30th of April.
30th of April is also a Thursday, like today.
But I have another matter which has opened and took away and couldn't finish before I took the flight. So that also may come on 30th then.
That matter is in the list?
Yes, in the list.
Which matter?
Give the number, I give them. This is in the hearing matter. High up.
That's not
Going
connected with this.
No?
That is not connected with this.
Then that was
Not connected. Mr. Mitra, when keep any of your learned juniors when that matter is called on, if you call on that matter, and we'll adjourn it.
Or you called on today. Then
Yes,
it's
let
taken
it be
up.
called on because the other said.
It's taken up all right.
This matter we are recording that.
Lordship may take up that matter very good today. Very good. Well, I shall.
So that matter also will adjourn if it's lengthy. The same principle applies. We'll wait for it to be called.
I wait for that matter.
You need not wait.
No.
Keep somebody. Since the matter.
I'm sorry, I shouldn't have mentioned it. I will wait for my turn. I should have waited.
No question of any. Sorry. The matter has been specially fixed before the regular bench. First of, however, comma, since the regular bench is not available today, and we do not want to, we do not intend to keep the matter parted before the
bench which is sitting today, comma, let the matter stand adjourned and be listed next on April 30, 2026 under the same heading. It will appear as a special case.
Actually, I beg to appear for item number 6. This one, number 1.
Same. Since the regular bench, comma, before which the matter has been heard in part, comma, is not sitting today, comma, we adjourn the matter to be listed next on April 30, 2026. Yes.
Oblige your lordship.
My lord, I'm not available on 30th April, my lord.
Let it appear in the list if you are not available, then we'll say.
My lord,
Yes.
kindly, my lord, after 8th, my lord.
Mr. Saha was appearing for us. He was the one making submissions, so I believe.
My lord,
Let
kindly,
them make the submissions on the next day, we'll adjourn.
my lord, kindly makes it after 8th, my lord.
After 8th?
We do not have a problem. my lord.
ভেরি ওয়েল, তাহলে এপ্রিল 30 যেটা করলাম আগের ম্যাটারটা এপ্রিল 30 হবে না, তাহলে মে
7ই মে কি পড়ছে কি বার?
মে 14, 2026.
Lordship, I'm grateful. I'm grateful.
Next, this is item 9. 9 who is appearing?
Well, I accept the appeal.
Mr. Devajiti Basu is appealing for the respondent, my lord. He's not come to court today, my lord. I'm paying.
Please
Not come to court, not come to court, my lord.
not come to court.
My lord, some personal difficulty, my lord.
Yes, Mr. Naghwatusi.
Your lordship, can you add this matter, my lord?
Your lordship might fix it in
An adjournment is sought on behalf of the respondents. First of let the matter stand adjourned for the day. Adjourned for the day means it will
May I file with the paper books?
keep it, file it on it.
Well,
Give copies to them. Mr.
No, we have some.
I was only some, but
Item number 10.
You are appearing?
Look, the pro forma respondent, lordship. State filed the appeal, lordship.
Since the appellants and the principal respondents are not represented today, comma, although the pro forma respondent is, comma, let the matter stand adjourned for the day. Please give your name, ma'am. Yes.
Number 11.
And just write pro forma respondent for 11 who is a,
So in this matter, I am led by Mr. Devajyoti Dev. I am for the official respondent, Eastern Railway.
who is the appellant.
Appellant is- So on last occasion, he was for his illness taken time, lordship.
This is the
Mr.
second occasion when none appears for the appellants. In this is the second occasion. আছেন এই ম্যাটারে? আচ্ছা, এটা দরকার নেই। None appears for the appellants at the time of call. Full stop. Next para.
Lordship, they are enjoying the interim order for the last 6 months.
None appears for the appellants at the time of call, comma, although the respondents are represented through counsel. Full stop. As a last chance to the appellants to argue the matter, comma, let the matter stand adjourned for the day. Full stop. It is made. Oh no, this order was already passed on the last occasion.
Yes, lordship.
Sit down. তাতে কি আছে? তাতে কি এইগুলো ছোট কি দরকার আছে? এই অর্ডারটা রয়েছে তো আগে যা We find from the order dated April 2, 2026 that an adjournment had been sought for the appellants on the said date. Full stop. We had made it clear in the said order that in the event further accommodation is sought by the appellants or the appellants fail to appear on the then next date, comma, ex parte orders may be passed in the absence of the appellants. Full stop. Today, comma, at the time of call, comma, none appears for the appellants, comma, nor is any accommodation paid for. Full stop. Accordingly, MAT 1294 of 2025 along with CAN 1 of 2025 are dismissed for default without any orders to cost. Next.
Deeply obliged.
But I am for the petition, my lord, take This is arising out of Urban Land Clearing Act.
Yes. What is the matter about writ appeals? If you can hear, we will hear out.
I can start it, but respondent not here.
You can start, Mr.
I can start.
File. Hard matter file ready. পরে ফাইলগুলো রেডি করো দীপঙ্কর মাথা সরা হ্যাঁ বাকি ফাইলগুলো রেডি করো Yes, Mr. Mitra, what is that?
This is Urban Land Clearing Act. There's a plot of land held by an HUF having 4 co-partners or 4 kartas. Now, question was whether it should be divided into 4 under the 7-4. That part was accepted by the learned judge and in the first court, divided into 4. Then out of that is, there are 3 appeals. The separate appeals by the different HUF. Judgment will be same. The then question was whether this property, which is now should be get exclusion on the ground of tank, number 1, and on the basis of the land appurtenant, or land which cannot be used for construction, that should be good judgment, and bill media. And the third ground was which court accepted. Number out of 3 grounds which are argued before the court, noted. And the reply to 2 grounds, first ground was given by the government authority. Learned judge, upon hearing both, have held in our favor. He has referred the matter to the authority to calculate, directing them to give the benefit of 7/4. But on the other 2 grounds, which arguments have been made or noted by the learned judge, and to which there is no reply from the other side, learned judge in the order just remains silent. That is why we have to prefer an appeal.
What was the genesis of this, Mr. Mitra? What did it arise from? The writ petition, it was from
final return file, and then final draft statement.
Final statement without hearing.
Final statement was without hearing. So
the writ petition was preferred against what? Tribunal?
Writ petition before Urban Land Clearing Tribunal.
So let us see the impugned order first. Should we look into the impugned order first?
Impugned order, yes.
Give an idea of the
The judgment below is at paper book volume 3. Volume 3.
Yes, volume 3 page.
Volume 3, Miller. The page number 200 and it starts for 216. Page 216. 216.
Yes.
In the case, but should I leave you or should read that piece? Or should I go on? Judgment is not.
That will also be RIP. Read in peace.
I only indicate, Milord, give the pages where we had argued those points, not dealt with at all. Said, may I give the Milord our submission is as Milord page paper volume 3 and even exclude area. Kindly Milord come to page 234. Page 234. Argument noting about after noting the facts, etc. Then page 234, kindly come to Milord. However, the partition refers to section 4(7) Proceed Act is a deemed provision. Then Milord, this Bill Murier case is noted. Yes, Mr. Shukriyan Mukherjee argued the matter, Milord. He is also will be available on the Then similar kindly read, it goes up to page 235 end. Our argument fully noted.
তারপরে ট্যাঙ্ক
Next.
পরেরটা হচ্ছে ট্যাঙ্ক ইজ নট ট্যাঙ্ক ইজ নট
Hmm. 10 minutes. Copy আছে না, 10 feet video হয়তো করে দিত। When that comes to the end of this, then I'll give you a letter next. এটা তো ডিল করতে
মেমোরিয়াল রিলিফটা দেয়নি,
জায়গাটা
ইভ পার্টিশনের উপর দিয়েছে। দেওয়ার কথা ছিল, ট্যাগটাও দেওয়ার কথা ছিল, এই দুটো কোনোটাই
মিডিয়া হচ্ছে ল্যান্ড বিকেন নো কনস্ট্রাক্ট
নো কনসেশন।
সময়টা আছে, কপি আছে,
কপি আছে,
আনতে বলতে আমরা
ছবি আছে তাই বলছে। চালিয়ে বলবো একটা ঘুরিয়ে নেবেন।
ডিম পার্টিশনের উপরে রিমান্ডটা করেছে। আমরা চাইছি বাকি দুটো পয়েন্টও রিমান্ড, এখানে ডিসাইড করেছে।
এইটা সময়টা দাও তো, এনে যে চারটা, এই চারটা
To got the relief ultimately.
তিনটে পয়েন্ট ছিল,
only will have 3 points involved.
Then why are you challenging?
That's right. Because, my lord, on other two grounds, Bilboria and the tank, Laneja has not given a direction specifically. Can you come to the order portion? Kindly come to the order at page 241. 37 among the video. The state has not preferred an appeal or cause of objection.
So
They
this
accept
stands final. These
For
findings.
the reasons stated above, the court is of the view petitioner entitled to relief as prayed for in the instant petition. That is all. That is would have been all right. But
All the
then,
relief has been granted.
then he has
Accordingly, the
accordingly draft and final statement prepared by him to being
respondents are directed to grant relief.
set aside and cancelled.
Yes, but respondents are directed
Then
to grant relief.
respondents are directed to grant relief to the petitioner, taking each of the petitioners as separate persons and declaring the ceiling limit as per section 47, but not taking into account the tank.
And can we look at the prayers of the writ petition, Mr.
Supplementary.
Unit status ওরা চ্যালেঞ্জই করেনি ওটা
Writ petition,
রেজিস্ট থেকে চ্যালেঞ্জ করেনি
page 224.
ফাইন্ডিং এর উপরই ক্লিক হবে
Of this judgment, Lord should get the relief set out. কোথায়? না এখানে না পিটিশনটা ডাউন আছে পিটিশন
Clarify ওখানে
রিপিটিশন প্রেয়ারটা কোথায় which page
I'll give the petition. Petition where, sorry, volume? Oh.
Must be somewhere around 50s.
This is allowed, then everything should have.
Yes, page 52.
No.
Page 52.
My lord got it. Dot সাহেব বার করে তোমরা আর করতে পারলে না কি
Page 52 of the first book.
আমারও লজ্জার ব্যাপার হলো কোথায় now may I which page is that?
Page 52 of the first one.
Yes.
Page 54. কোনটা volume 1 তো
Volume 1 আপনারটা যেটা আছে ওটা page 54 চলে আসবে
পেয়ে গেছে এতক্ষণ
What is the main prayer, Mr. Mitra? Mostly on cancellation.
সাপ্লিমেন্টারি অ্যাফিডেভিট আমরা ইউজ করেছিলাম এখানে আমরা অ্যাডিশনাল পয়েন্টস গুলো দিয়েছিলাম
and there's a supplementary affidavit and taking the additional ground report cancelling the proposals.
See, everything is on the draft and final statement.
Yes.
So you have asked for that, do further proceedings on basis of that, recall and cancel that. And prayer C is
yes,
also no further steps in respect of that. And D is
certiorari. Specifically, kindly come to below page 125 of the paper.
125.
Volume, next volume, Milord, not in this volume 2.
This is what the same writ petition.
Yes, supplementary affidavit. Paragraph 6 at page 129.
Page 129, paragraph 6. This is the ground taken.
So you want a deduction on the tank?
Paragraph 8, Milord.
Yes,
On the 2Q1.
And Billy Moria 1/3.
Billy Moria, we want to see the judge.
Yes, Billy Moria.
Paragraph 6 to 7 were probably relied on by the judge. 6 to 9. Probably.
Come to paragraph 8, or to get a summary. That will be perhaps very convenient.
Yes.
Making clear deduction following emerges.
Paragraph
131.
What was the exact exclusion as per Billy Moria? What would be that?
1/3 of the total covered area.
In that, as
which is covered by the
not
space
constructible.
Which will be under which provision?
Schedule 16 of the Calcutta Municipal Act 1951, which mentions how much area is to be kept vacant in a land which is constructed upon. That is 1/3. Billy Moria says that that has to be excluded from vacant land jurisdiction.
So you would be happy, Mr. Mitra, your client would be happy if this chart, according to this chart, relief is granted, that it has to be calculated.
Yes.
By treating them to be individuals.
Yes.
In terms of this chart, page 131.
Taking into account Billy Moria and tank.
See the chart? It's there in the chart, page 131.
These are the parameters.
Right.
If in terms of this it is done, then because the learned single judge held on in your favor on all these counts.
Na, ওইগুলোর কোনো finding দেন।
On
only
those
4/7 finding দিয়েছে।
May I give you lordship?
Yes, let us come to that chart once.
might help your lordship.
Yes.
This chart.
Just.
finding the
Kindly see me lot. I've made a summary that might help your lordship to
chart it. Chart
It is also on the affidavit. Lands to be excluded on the following three grounds for calculation of vacant land. Our chart. Exclusion of land for
One has been granted.
petitioners, being part, etc. They do it for 7. Then areas to be excluded so much. Submission. Our submission recorded at page 229. Submission considered and accepted at page 239 to 41.
2 or 3
Good. Now, Mira, this is
On tank,
this-
there was no finding.
there was no finding.
yes.
Let us see the impugned judgment there.
Then, Mira, regarding the Bilimoria, ground number 2, that submissions are
Bilimoria was probably held in your favor.
page 234, 235,
Score a finding that
234,
Come to the
235.
finding.
Can you take serial number 2, exclusion area of land on which construction was permitted as per Rule 20, Schedule 16 of Municipal Act, being applied as per the judgment Honorable Supreme Court in Bilmoria's case. Area of land is mentioned 1/3, 832. Submission noted and discussed in a judgment at page 234, 235. Then considered at page 234, 235, noted. Then submission noted, considered and not dissented from, but no direction given.
Bilimoria tanker উপরে কোনো
Yes.
finding নেই
Now, no
Bilimoria
dissented from,
judgment
but no
will
direction given. Then 3, exclusion of proportionate area, that is being tank. Submission noted and discussed in judgment at page 235, 236. And as also in a judgment supported, these judgments were referred to 89 Calcutta.
Yes, relevant portion of Bilomoria judgment, which relevant paragraph?
yes
11 paragraph, Millard, in 234.
8 and 8 and
Contact-
Bilimoria
Oh,
judgment
Bilmoria paragraph. Actually,
6 to 9 were probably
and
considered.
this Millard, the case number cited, and submissions noted, considered, not dissented from, but in fact, even state did not dissent from these submissions, our submissions.
6 to 9 were considered by the learned trial. Assembly.
para 6 to 9 submissions
Paragraph 6 to 9 was.
finding at 13
Yes,
finding at 13 finding at 14 6 to 9 13 14
There is no construction on that part,
no construction
but it's not permissible also.
it's not permissible
Therefore, it comes within this 2Q.
2q1 so that has to be discounted independently
This 2Q1 is there. Is there.
yes.
What was the reasoning of the authorities on 2Q1?
Authorities did not notice it because Bilimoria had not come then, but Bilimoria is a clarificatory judgment, therefore it dates back to the beginning of the act.
That our prayer was for setting aside that draft, right?
সেটা allowed,
Not
That has
with
been done. That
effect.
has been given.
If that is allowed, nothing else required.
remand
That has been given.
No, no question of remand. Court gave us less than that. After allowing this petition, that means no effect will be given to the draft. There is no vacant area, no excess vacant area. But court remanded.
The reassessment was directed also.
Yes.
Reassessment. That was not our prayer. Our prayer was set aside. Set aside the draft and final. And
So the language is the
declare-
response are directed to grant relief,
Yes.
taking each of you as separate persons.
If the draft
Now,
and
those
final,
each of you are the petitioners in this.
our relief have been narrowed down
আমরা একটা
to one only.
আমরা একটা সাপ্লিমেন্টারি ফাইল করেছিলাম
And
4.7,
supplementary
why did you
affidavit.
rely on 4.7, 4th section 4.7?
Yes, Vinod,
For the
if
tank.
I kindly come to see the supplement affidavit.
where it is being filed as a HUF, every member has to be separately.
That part is
assessed.
accepted.
Tank, what was your submission?
Tank is not vacant land.
But we get that
That is
in the statute.
number of statute, it's again part of land which cannot be constructed upon. Therefore, tank is not vacant.
So comes under QI also.
Yes, schedule rule 2, 60. Here not we have summarized our submissions.
Tank is not vacant land, judgment আছে দেখুন impugned judgment এর side
এখানেই তো আছে ট্যাঙ্ক জাজমেন্ট আছে এবার এখানে দিয়ে দিয়েছে তোমরা এখানে জাজমেন্ট দিয়ে দিয়েছে
এইটা একটু কাছে আছে 81 Calcutta 126
does not include land on which construction of a building is not permissible. যেখানে পারমিসিবল না বিল্ডিং প্ল্যান সেখানে সেটা বাদ যাবে, which is correct. থার্ড যেটা ওনারা বলছে সেটা হচ্ছে ট্যাঙ্কটাও এর মধ্যেই পড়ছে, যেহেতু ট্যাঙ্কের উপর কনস্ট্রাকশন হ্যাঁ দেখুন এই ব্যাপারে দেখুন না পার্টিশন তো দিয়ে দিয়েছে, ওরা চ্যালেঞ্জ করছে ইন্ডিভিজুয়াল
here 1981 or Calcutta here 1981 Calcutta
judgments are referred to in that note also.
judgment take into that. This Calcutta
তারা 19 এর আগে পাবে বিল মিডিয়ার প্যারাগ্রাফ দিয়েছো বিল মিডিয়া
There are clearly 1920. মানে ওরা ওটাই ক্যালকুলেট করবে কোন পোর্শনটা পারমিসিবল নয়, এইটাই যদি ফ্যাক্টস অফ দ্য কেস অ্যাপ্লিকেবল। ট্যাঙ্ক বাই ডিফল্ট আসছে না কেন, তার উপর কনস্ট্রাকশন করা সম্ভব। এই তো এই লাইনটা কি বলছে কিউ আই এর ক্লিয়ার আইতে বলছে ভেকেন্ট ল্যান্ডের ডেফিনিশন দিয়েছে, তাতে বলছে ল্যান্ড অন হুইচ কনস্ট্রাকশন অফ বিল্ডিং ইজ নট পারমিসিবল। দুটো কনোটেশন এদের ক্ষেত্রে, একটা হচ্ছে ট্যাঙ্ক হলে তার উপর কনস্ট্রাকশন করা যায় না বাই ইটস ভেরি নেচার, আর সেকেন্ডলি হচ্ছে যেখানে বিল্ডিং রুলস বা বিল্ডিং যে governing regulations আছে তাতে পারমিসিবল। The authorities cannot show that they have obtained any fines and plan to construct building. Yes. This would be our respondents could not show that. No, respondent did not construct, nor is there any admitted position. Neither did not obtain any plan. এবং সেটা চ্যালেঞ্জ ওটা মডিফাই এটা কি বলছি যে এইটা যেটা রয়েছে তার সঙ্গে ইন অ্যাডিশন আমরা অ্যাড করে দেবো যে এই টপিকটাকে নিয়ে it is modified to the effect that such relief shall be granted to the respondents by treating them to be individuals in the light of the judgment delivered in Bilimoriata Court Korodava by exclusion of the land on which construction is not permitted in terms of the existing law, as well as the tank on which by its very nature construction is not so we are adding those two in this modifying and adding.
But had the landlord stopped by saying writ petition allowed, I would have
no Mr. there is a difficulty there. You did not specifically make these prayers also. We have seen the prayers. You sought for cancellation. All the prayers
washing of the everything.
That was your prayer.
Can we add those two grounds?
Supplementary একটা file
supplementary is not a prayer.
Supplementary.
add হয়নি
You brought that to the notice.
Supplementary, I have also seen that.
So all the prayers are granted.
হ্যাঁ ঠিক আছে না ঠিকই বলছেন
That means if the deed is allowed mean draft statement, everything quashed. Then matter ends there. I don't have anything more to ask for. Kindly add those two grounds to be considered.
The none appears for the respondent state at the time of call, comma, nor has any appeal been preferred by the respondents against the common judgment. This was a common judgment, one judgment, a
Yes, one
separate
judgment.
judgment. By the common judgment, against the common judgment by which all the writ petitions, comma, which are the genesis of the present appeals are concerned, comma, were allowed. Full stop. Next para. Learned senior counsel appearing for the appellant in each of the matters argues that although the learned single judge accepted all the propositions, accepted the proposition advanced by the appellants to the effect that individual members of a Hindu undivided family, HUF capital, bracket is short from HUF, bracket close, are treated to be individual members by dint of the deemed partition as contemplated in section 4 within bracket 7 of the urban land within bracket sealing and regulation bracket close act, comma 1976, and directed the respondents to grant relief to the petition to the appellants, taking each of them as separate persons and declaring their sealing limit as per the provision of section 4 within bracket 7, comma, the learned single judge, comma, although considered the arguments of the parties on two other cardinal points involved, comma, did not categorically return any finding on those. For next para, the first such issue, comma, on which no specific finding was rendered by the learned single judge is whether land which is land within the subject plot, comma, which is vacant and no construction is permissible as per the governing building regulations, comma, should be excluded from the definition of double inverted vacant land as defined in section 2 within bracket q, small q bracketed within bracket small I of the 1976 Act, full stop, para. The second question which came up for consideration is whether the tank, comma, which comprises a portion of the subject plots, comma, also comes within the purview of the exclusion of section 2 within bracket small q within bracket small I by dint of its very nature. For sub next para, upon a consideration of the arguments of learned senior counsel for the appellants, comma, we find that the learned single judge, comma, although not accepting the arguments of the appellants specifically, comma, did not deviate from such arguments in the ratio of the impugned judgment. Full stop. Moreover, comma, the respondent state also did not categorically rebut such contentions of the appellants by any cogent argument or citation. For sub next para, even on merits, comma, we find that the second and third grounds, comma, which were omitted to be adjudicated upon specifically in the impugned judgment, comma, are tenable in the eye of law for the following reasons, colon, niche, as held by the Honorable Supreme Court in State of Maharashtra and another versus B stop E stop Billy Moria and others, comma, reported at 2003 7 SCC 336, comma, land on which construction cannot be undertaken in terms of the governing building regulations comes within the purview of section 2 within bracket small q within bracket small I of the 1976 Act. Full stop. Next para. Secondly, comma, by its very nature, comma, construction cannot be made on a tank, comma, which is a water body, comma, thus bringing a tank also within the ambit of clause small q within bracket small I within bracket of section 2, comma, since no construction can be said to be permissible on such a water body. Full stop. As such, comma, we find merits in the arguments of learned senior counsel for the appellants and dispose of the present appeals accordingly. Full stop. Next para. MAT numbers সবকটা নাম্বার দিয়ে are disposed of by modifying the impugned judgment dated November 17, 2023 passed in WPA চারটে WPA যার থেকে অ্যারেস্ট করছে দিয়ে respectively to the following extent colon the respondent authorities shall grant shall assess the what is the language is grant relief
Vacant land.
the respondent authorities shall recalculate the permissible ceiling limits of the subject plots by treating each of the writ petitioners stroke appellants comma who are individual members of the concerned HUF in their individual capacity full stop secondly comma the respondent authorities shall omit shall exclude the portion of the suit plots subject plots in respect of which construction of a building is not permissible under the building regulations in force by keeping such portion of the property outside the ambit of vacant land as contemplated in the 1976 Act. Full stop. Next para. Thirdly, comma the tank shall also be brought under the exclusion in calculating ceiling limits, comma deeming the same to come under the exclusion as provided in section 2 within bracket small q within bracket small I of the 1976 Act. Full stop. Next para. In view of the long pendency of the matter, comma, it is expected that the respondent authorities shall carry out the aforesaid calculations at the earliest, comma, if necessary, upon giving a limited hearing to the appellants and or their representatives and take further steps accordingly in accordance with law.
If it is found that it is within limit, তাহলে shall.
Comma. No, they'll calculate. You have directed them to calculate.
If they find it is within ceiling limit, then they shall declare the same and so accordingly.
So we make it clear that if the subject plots are found to be within ceiling limit after giving effect to the aforesaid observations, comma, the respondent authorities shall declare the same accordingly in terms of law. So next para, it is made clear that we retain the portion of the impugned judgment whereby the draft and final settlement
statements.
The draft and final statements which were assailed in the respective writ petitions was cancelled and rescinded.
And only request coming plan as soon as possible.
We have
It
put
would possible that preferably within
no, we are not putting that due to the election.
8 weeks or something. Preferably, even your please, that is sufficient. That's all.
2 মাস 3 মাস preferably যেখানে বলেছি shall be as expeditiously as possible একটা কথা বলেছি expeditiously দিয়ে কি সার্চ করলে বেরিয়ে যাবে expeditiously দিয়ে কি সার্চ করলে বেরিয়ে যাবে preferably within 3 months from the date of communication of this order judgment to the respondent authorities.
Only one thing, Lord. Malad has said, Lord, limited hearing, Malad has said, if any necessary, that is provided under 8 and 9, he has to hear me. So, if your Lordship kindly.
Need not. If they find that in terms of a judgment, don't reopen an opportunity of hearing.
No.
They'll reopen the entire thing.
My lord, I am also present here, Lord.
Yes, Mr. Mukherjee, noted and respected. হ্যাঁ তাহলে এফএম WPA প্রত্যেকটা পেপার বুকে দেখবে WPA নাম্বারটা চারটে WPA থেকে অ্যারেঞ্জ করেছে পেপার বুক কভার গুলো
My lord, kindly pardon me, my lord, item number 11, my lord, I am seriously ill.
What did you কি করেছি আমরা?
Dismiss for default.
At the we have adjourned.
My lord, no, my lord, dismiss for default if I am not wrong, my lord.
Dismiss for defective.
Dismiss for default, my lord. My
No
lord,
matter has been dismissed for default today.
item number 11, my lord.
Dismissed for default.
My lord. My lord, on the way, my
No,
lord.
no, this was the second occasion we
My
had.
lord, I know, my lord, because,
Where is your other side? Bring your other side.
my lord, I do not.
Bring your other side. Somebody ought to have paid for time.
My lord,
No, bring your other side only, then we can. Or file an application on that ground.
then, my lord, I am bringing, my lord, because 200 people will be evicted, my
We
lord.
appreciate fully, but you have to file a restoration application. We gave you 2 chances. This is the second chance. On the last occasion, we had recorded that if further adjournment is sought, then we categorically requested the learned junior to make alternative arrangements.
My lord, I am.
So we are not answerable for orders. Sorry, file an application.
My lord, I am bringing the other side, my lord.
If you can,
My
then
lord.
take a chance. Next. ওটা দিয়ে Doctor.
It is our application. This is our appeal.
If you are there, Mr. Odhikari, it won't be concluded today. We have heard substantially in the other bench. We'll take it up when the regular bench is sitting.
No, my lord, it is the
We have a
regular-
reputation to
My lord,
defend.
one thing, my lord, that it's a very short matter, no problem.
We know short matter. We are hearing it for 3 days.
But I think
Since the regular bench is not sitting today, and the matter was
But my lord, that is the
substantially heard on
objective is there,
several
my lord. But
substantially heard on several occasions, let the matter stand adjourned for that.
But my lord, that one thing may be done, my lord, that when the other side is also here, then my lord, I think that I am making it very short version that so that my injunction be continued, my lord, at least
Lordship,
because
we have
that-
submitted our written notes of argument.
My lord, that
It's a expired
At
lease.
least-
Your lordship has held
That
that
is
is a commercial contract. The remedies before the damages, and the order passed by your lordship that was tested before the apex court that has been dismissed by the honorable Supreme Court. Lordship, this judgment.
We are extending the interim protection till
Yes, my lord. that is-
till
Lordship, in this way, it is going for a considerable.
No, we are unable to take it up. That is why it
That
has
is-
to be
my lord,
extended.
we should not suffer for it.
the interim protection
ready.
granted earlier stands extended, shall stand extended till May 15, 2026 or until further order, whichever is earlier. Next.
I am deeply obliged.
It will remain in the list. Next week, I am not there. I am in Port Blair circuit for 2 weeks. That's why.
ঠিক আছে তো চলো
I am for the respondent. Number 1.
Who is for the appellant?
And
Lordship,
17
these
I am
are-
for the appellant. Related or matter.
This also relates to the same thing.
He was the writ petitioner.
He was the land mafia.
No,
He's not the land
not
mafia.
land sand.
What happened in this matter, my lord? I was allotted 3.
So what's then that? What's then there?
No, my lord. I want a better footing.
Better footing.
My lord, I was deprived rather. in
You're the
this matter.
chairman of the district committee.
What happened, my lord? I was allotted 3 mining plots, my lord, being the highest bidder. My lord,
We are being very frank. If it requires a long hearing, we won't keep it parted before the irregular bench. So that's what.
May I file the paper books, my lord, that a formal order?
Paper we have served copy.
Paper-
No,
copy
paper
has been
will
served.
take on record when you next come back. We are short of space. Just see the left side. Learned counsel for the parties submit that the paper books are ready in the matter. Push up. Let such paper books be filed on the returnable date. Push up. In view of the unavailability of the regular bench, we adjourn the matter for the day. For the day means not before 30th of April. 30th of April, I'll be coming back the regular bench.
Is my lord, the mining plot may be encumbered by creating a third. That
If
will-
they've not encumbered till now, then what can be?
Actually, regular
Why not? মানে হচ্ছে injustice হয়ে যায় বলে আপনি যেটা বললেন একদম ঠিক বলেছেন। আমরা নিতে পারছি না, একদম ঠিক। একদম ঠিক। এটা অলরেডি এনজয় করছি। ঠিক বলেছেন। আমরা নিতে পারছি না।
এটা থেকে 15 তারিখের মধ্যে চলে আসবে।
এক্স্যাক্টলি। চাপে আসবে না। সেপ্টেম্বর মাসে ওটা চলছে। Bondava, the same logic applies to if you are appearing, it will take some time. Must be some intricate matter or something. Can it be disposed of? Short matters will take
No,
up to.
it is not a short matter.
Not a short
Only thing, my lord, your lordship is fixed it for hearing.
No, it's already for hearing. We'll record our inability. We'll record the reasons that we are unable because the regular bench is not sitting. Since the regular bench is not sitting today, comma, we do not intend to keep the matter part heard before the bench, before this bench. So accordingly, let the matter stand adjourned for the day. For the day means 30th of April, we are next session. We are actually eager to take up these matters. If Justice Bhattacharya was there, we would have taken up.
Yes.
Item number 20.
I am for the respondent.
Civil.
Appellant, my lord.
So order 7 rule 11 plain rejection of these short matters we can take up. But since the regular bench is not there, you are also there, Ms. Deghosh. So if it's unless it's a short matter like plain rejection or something like that, we won't take up today. আগে গেছি বাকিগুলো ঝগড়াঝাটি করে পটাতে পারছি Yes.
18 I am for the state respondent. 18 and 19.
18 and 10 long over. You are not there.
It does now I am count.
Give your name. Give your name. 18, 19 and now 20. Yes, so we are adjourning this on the same order. Same order. Since the regular bench is not sitting, order.
Grateful, my lord.
ফাইল দেওয়ার আগে দেখে নেবেন বড় ম্যাটার এখানে জিজ্ঞেস করবো শুধু তুলতে হবে না আবার নাম মনে
Getting in the regular course, my lord, in the list
No,
after.
no, it will retain its position in the list. It will remain in the list. I will not be there for 2 weeks. I'll be in circuit. That's why it will be in the list. That's why we are indicating frankly to the learned council that we'll be able to take up only not before 30th of April. Hearing matters.
Item number 24.
I'm appearing for the state, my lord, led by Mr. Galib.
21, your lordship, Mr. Shonak Bhattacharya is
21, what is the nature of the appeal?
brief.
Matrimonial?
I'm not aware because.
No, well, not today. This order record করতে হবে.
Only make it
Matrimonial just mediation. নেই তো টাইম চাইতেস আসল লোকেরা নেই এই যদি মিডিয়েশন এগ্রি করে যায় চেম্বার থেকে তাড়িয়ে দেবে Not today. Nothing. Not today.
No, my lord, I was appearing, my lord. I'm led by Mr. Ghosh.
What is the matter about plain rejection?
No, it arises out of a refusal to grant me a specific performance of contract.
Why can applications for what? This can?
I'm pointing out.
Can গুলোর সঙ্গে অ্যাপ্লিকেশনের শুনানি করবে
One was for early disposal, and other one was already disposed of. It's a substitution application disposed of by Logima.
No, we are not making it part before this bench.
No, it should take some time, my lord.
Yes, obviously it will. Specific
It will take
performance.
some time.
এটা হচ্ছে ওই আগে যে অর্ডার গুলো দিচ্ছেন যেখানে কাউন্সিল অ্যাপিয়ার করছে ওদের নামটা রেকর্ড করার জন্য ওই অর্ডারটা রেকর্ড হবে যেখানে কেউ অ্যাপিয়ার করছে জাস্ট
One thing may I just point out, my lord, in the paper book while preparing for the matter, my lord, there was the entire depositions was that of the DW1 and DW2 was there, but the exhibited documents were not there. It's in the LCR. My lord, what had happened? We
prepared a compilation.
Prepared a supplementary paper book since we had the
Give a copy to them.
Firisti copy.
Give a copy to them
Yes,
in
my lord,
advance.
that is.
On the next day, mention this. We'll record and take it on record.
Yes, my lord, that is well.
Because today we won't take it home.
No, my lord, I was just to serve
Copy to them
so that they can go through it as well. I'm grateful, my lord.
Thank you. Not today. Mr. Ghosh, hearing matters, long hearing matters, we are not taking up today. Regular bench is not there. Oh, you are in the previous matters. Your junior will give the explanation. Not today, not today. Already record.
Yes, my lord, I am for the respondent. It is a matrimonial matter.
Matrimonial, then it will take some time. So, not today, just not today. Same, not today, just
26 it's a
allowed.
matrimonial.
Not today, not today.
27, I'm for the appellant, my lord.
What sort of appeal?
Shoot for partition dismissed, preliminary degree refused. Challenging.
Not today.
Item number 20.
They're just making note.
Exponent husband, my lord. Exponent husband, 26.
20, 29.
I'm for the defendant, my lord. My
What
lord,
is the matter about?
my lord, this is a
Plain rejection
plain, not plain rejection.
on merits.
Yes, ma'am.
We are making it not today. not regular benches.
My lord, actually, my lord, as per direction of Honorable Supreme Court, a mediation process is going on and
Oh.
it is to be scheduled on 17th of this month.
17. So we're just making not today. We won't take it up before 30th of April.
My lord.
So apprise us on that date. We are not recording anything. If it is successful, we would be the happiest. All of us would be happy.
All of us.
Lordship, I'm appearing on behalf of the appellant.
We're making not today. This bench.
Lordship, it's a small matter, Lordship. Only for
For small matter, then we can take
yes, Lordship. It's just an application.
it. We are passing it over. Just inform your other side over the phone.
Okay, okay.
Do that. We are passing over.
Grateful.
We'll call soon. Immediately inform your others. Someone be in court. Come back in 2 minutes.
I'm for the appeal.
Big appeal.
Matrimonial appeal, not big, but
matrimonial appeal is always. We can finish it today and pass judgment. Is
no,
it that
actually, in
sort
the
of
last
matter?
occasion, my lord was pleased to take instruction from my client because my learned
Mediation.
No. Submits learned advocate for the respondent husband submits that he has already got married. So your lordship asked me to take instruction. So I do not want to proceed with no fruitful purpose will be served. But your lordship observed that the alimony.
Permanent alimony, we will keep it open to appraisal jury.
Yes, my lord.
You have already contracted marriage.
No, my lord. Actually, Mr.
Don't appear to be. Your client has.
No, my lord. My senior is appear married. He is
Your
engaged.
senior has contracted marriage. That you. You have to take instruction whether. I mean, you submitted on the last occasion that he had. The
Well,
order
I don't have any brief today.
File the din. ওনাকেও দিন।
জিজ্ঞেস করতে বলেছেন জিজ্ঞেস করবো পার্মানেন্ট এলিমেন্ট এর কনসিডার জানতে পারবো এক্ষেত্রে ডিগ্রি পরে পড়ালে জুরিসডিকশন করতে যেতে পারে আমরা তো সেকেন্ড টাইম পেয়ে যেতে না আমরা তো আমরা পার্মানেন্ট এলিমেন্ট অ্যাপ্লিকেশন করার লিবার্টিটা ওয়াইফকে দিই এখানে এটা করার প্রশ্ন নেই এজেন্সি ওরা করতে পেরেছে না ওরা পেয়েছে পয়সা খরচা করে লিটিগেশন
লিবার্টিটা দিয়ে আমরা রেকর্ড করবো যে
Maintenance and alimony issue will be kept open to be
So we are dismissing your appeal for non-prosecution with the limited rider that we are giving you liberty to proceed. We'll give the context why you are saying that.
Of dismissed.
No, then we have to hear it on merit. Either we hear it on merit, that's why we permit you to take instruction.
No fruitful purpose will be served.
No, we'll record that. But if you proceed with the appeal, then we'll have to hear it on merit. If you win the appeal, no fruitful purpose will be served. If you win, you will have you will have a shotin.
Yes, my lord. Kindly record my submission.
No. We want clear thing. We don't want to impose anything on it. If you want to proceed with the hearing of the appeal, we are happy to take it up. We'll take it up on the regular basis. We gave you time for that purpose only. We gave you a week's time, not 1 day, to take adjournment, to take instruction.
No, lordship,
we have recorded whether the appellant wants to proceed further with the appeal. If you say, I don't want to proceed further, only then we will dismiss it.
Yes, then your lordship,
we had adjourned the present appeal has been preferred by the appellant wife against a decree of divorce obtained by the respondent husband. First up, by an order dated February 19, 2026, it was recorded that that learned counsel for the respondent husband had submitted that after passing of the ex parte divorce decree, the respondent has remarried and has a daughter of about 6 years from the second marriage. First up, in such context, we granted a week apostrophe adjournment to the learned advocate for the appellant to take instructions as to whether the appellant wife still wants to proceed with the appeal. First up, today, when the matter is called on for hearing, learned counsel for the appellant, on instruction, submits that the appellant wife does not want to proceed with the appeal, since no fruitful purpose would be served even if the appellant succeeds. Full stop. Next para. Appreciating such circumstances, comma, FAT 67 of 2025 is dismissed for non-prosecution without any order as to costs. Full stop. However, comma, we make it abundantly clear that it will be open to the appellant to take out an application for permanent alimony before the jurisdictional court, comma, in the event the appellant so intends. Full stop. If such an application is filed, comma, the same shall be decided in accordance with law by the concerned court upon giving opportunity of hearing to both sides without being influenced in any matter by the dismissal of the present appeal. Thank you. Get এটাতে একটা ডিগ্রি ড্রন আপ করতে হবে অনিন্দিতা একটু খোঁজ নিয়ে একটা ডিগ্রি ড্রন আপ করতে হবে কিনা ডিসমিস করলাম ফর নন প্রসিকিউশন যদিও তাও হ্যাঁ হ্যাঁ একটা দিন তো একটা শুধু লাইন অ্যাড করে নাও ডিসমিস ফর নন প্রসিকিউশন উপরটা thereby affirming the judgment and decree dated December 17, 2016, passed by the learned additional district judge, fast track court at Barakpur, district North 24 Parganas, in matrimonial suit number 112 of 2016. Next.
I beg to appear for the appellant in this matter, 32.
Yes. 32 is a small matter or a big matter?
It's a rather small matter,
there's nothing
but there
called
are
a
only
small
three judgments. There are only three judgments which I need to place, but the matter is very simple, my lord. Whether a party in a
Small
mutual
by
divorce,
small we mean whether this irregular bench can pass a judgment in court. I mean that depends on our competence also.
That may be able to be passed, but I'm also led by Mr. Shuddha Banerjee, and Lord, my submission would be here. The short question.
What is the short question? Let us see. You are for the appellant.
I am for the
you.
appellant.
Yes. Who is for the respondent?
I am for the respondent, Your Lordship.
Very good. Yes. What is the matter?
The short question involved is whether a
Lordship.
party in a mutual divorce can withdraw consent after Lord enjoying benefits under the terms of settlement, under the settlement that has arrived at between the parties. Here, my lord, the wife has, after taking, my lord, part of the of maintenance, my lord, has now stopped appearing before the court. If your lordship kindly takes the impugned order, the paper book is filed.
Where is the impugned order? Which page?
The impugned order, your lordship kindly find page 3.
Lordship, in this matter, two questions to be considered. Whether a dismiss order be appealable or whether in 13B any party can withdraw their consent or not.
Definitely. Where is the impugned judgment first? We want to look at
page
that.
3. If my lord kindly comes to page 3.
Page 3.
Not page 3.
Page 3 of the paper book is the middle of the something.
But the informal paper. Informal paper book first.
Yes.
But your lordship will kindly find order number 4. Order number 4 dated 21st of January 2025. Here, the petitioner, the first petitioner was the wife. But although the respondent is present, it is recorded. Although it is recorded as respondent, it is the petition number 2 really. Number the petitioner, which is referred to in order number 4, is the petition number 1, the wife. The wife was not present. It was adjourned as last chance.
No, this is
I'm sorry.
Case was adjourned as a last chance and fixed for conciliation.
What
are you saying?
I'm sorry. Lord, kindly takes the next order. Kindly takes the next order.
This was not in serial way.
Yes, page 19.
Yes, but I'm sorry. Yes, ma'am. I'm so sorry. Kindly, the pardon. Order number 5, 25th of February 2025. But Maxwell is hereby dismissed for default.
ডিফল্ট যদি হয়ে থাকে তাহলে এটা কি করে অ্যাপিলেবল হচ্ছে? এটা কোনো স্কোপই নেই। ডিফল্ট বলতে ডিফল্ট ডিফল্ট নন প্রসিকিউশন থেকে ডিফল্ট হতে হবে। এসেন্স এটা কি দেখতে হবে?
essentially যে না না পেয়ে যা বলেছে না না পেয়ে
না, ওকে জিজ্ঞেস করুন রেসপন্ডেন্টকে, শুধু ডিসমিসাল ডিফার করে ভুলিয়ে দিলে তো, ও যদি বলে যে আমি প্রসিড করতে চাইছি না, এই জন্য আমি অ্যাপিয়ার করছি, রেসপন্ডেন্ট ওয়াইজ বলুক এখানকার রেসপন্ড। ও যদি প্রসিড করতে চায় না, তাহলে তো এটা হ্যাজ দ্য এফেক্ট অফ ডিগ্রি, কেন তাহলে তো ডিসমিস হয়ে গেল 13B তে, 13B টা করলে ডিসমিস হয়ে যাবে, সো 13B শুধু ডিফল্ট, লিনিয়ারলি ডিফল্ট নয়, 13B তে নন প্রসিকিউশন হয়ে যায়, শুধু ডিফল্ট সে পড়ে যায় না।
You are for the wife.
Yes,
You are.
Lordship.
I am for,
Yes,
no,
You are
I am
Mr.
for the
Patro.
husband.
Mr. Patro.
Yes, Lordship.
Mr. Patro, do you want to proceed with the 13B?
Yes, yes, Lordship. The rest amount they are going to pay, then it will be over. Rest amount they have.
If that be so, we'll record that. We'll say, although the appeal is not maintainable strictly, if it was for default.
Lordship, another one. 13(1) is proceeding in the district, additional district judge court in the district Bankura, Khatra.
All right.
So, and they have already appeared there. They have submitted their written statement also.
Oh, Mr. Banerjee, one thing. Now, your learned friend has a point when he says that it was basically dismissed for default. So
Yes,
it's not a decree under Section 2.
Yes, yes,
Not a
Lordship.
decree under Section 2.
And
But,
your Lordship,
may I,
If you
may
liberty
I,
to file a revisional application, then what can be done?
may I address,
Oh,
may I
Lordship,
address on
actually,
this issue? This,
dismissal against dismissal, no
So
appeal.
if it was recorded that the husband, that the wife did not want to proceed with the matter, if that was expressed and on that ground it was dismissed, 13B was dismissed, then we could
No.
have considered it would not be a mere dismissal for default.
No, Lordship, last order, I'm reading out here, Lordship. Respondent is present filing Hajra. Petitioner is absent without taking any steps. None appear on repeated call on behalf of the petitioner. Hence, it is that the instant match suit number 105 of 24, same is hereby dismissed for default. Only procedure is 913, your Lordship.
Right. 913 or revision is, we will not express anything on that. We
but,
just say not.
but the
Mr.
query was
Banerjee, it's
placed
not
on me. May I
appealable.
just-
He's
May I
right.
just
Mr.
place,
Patro.
may I just place, may I just
Lordship,
place,
out of
may I
that,
just place.
if they want to proceed, there is the another provision which has been filed by the wife at 13(1). They have already
May I
submitted
just
their
place?
reply.
No, Mr. Patro, let us understand this. If you have filed a 13(1), therefore, by your conduct, you have shown that you do not want to proceed with the 13B.
No, Lordship, actually, they are in separation last more than 7 years. They
So
won't
that we
like-
can understand. But you did not take out any application for order under Order 9 Rule 9. This is Order 9 Rule 13 would not be strictly applicable because both of you are petitioners.
Yes, yes, yes,
So
Lordship.
Order 9 Rule 9 could be filed by either of you. You did not file any Order 9 Rule 9. Suppose if they file an Order 9 Rule 9 today, now
No,
on the ground
Lordship.
that it is dismissal, this will only delay the matter for both of you. So
Yes,
if you
yes, Lordship.
agree to a mutual consent divorce in terms of the 13B petition, then
Lordship,
let us relegate you to their.
Lordship, the wife is ready to proceed in 13(B) or any way if they have paid the rest amount. They have
Then
denied
Mr.
on that day to
Well,
pay
no,
the rest amount.
amount means which was agreed in between you in the 13B petition itself.
Yes, Lordship. They
Very
have
well. Then Mr. Banerjee, they're agreeable. We are doing
If
this.
that is so, if that is so, but if that is so, if they are
No, we are
agreeable to
telling you.
accept the
We are
amount,
telling you. We are converting this appeal to a civil divisional application. We'll direct you to file the necessary pleadings within a week, and conditional upon that, we are passing an order. We are setting aside this order. We are relegating it to the trial court, and we are saying that the 13B revives, subject to the husband paying the agreed amount. The wife, and we record that subject to the husband paying the amount agreed, you are willing to proceed with the 13.
my lord, I'll be so much grateful for that. And my lord, I can even make, if I may make one
Be
more
grateful to
submission.
your
even
friend,
to-
Mr. Patro, also.
Yes,
Mr.
sir.
My lord, half of the
My lord, I can also do this.
Half of the amount has been paid. That is what
Yes,
I
yes,
said.
yes.
But I can also do this.
Balance amount they'll pay, and you just agree to that.
Yes.
But I can also do this. My lord, we can come back before your lordship after payment
No,
of the balance
there
amount.
is some difficulty. Order 23 does not strictly apply. If there is a 13B,
Yes,
there are certain
true.
judgments,
But
Mr.
Lord,
Banerjee, either way. So
Yes,
it's,
Lordship.
whether we can grant or not, it's difficult to
No,
see.
no, Lordship. There should be an application 99. Should be an application.
But there cannot
And then
perhaps be.
delay, your Lordship might be
No, need not be.
condoned.
Need not be. That's a technicality we are foregoing. If you,
Anyway,
literally,
yes,
it's Mia Bibi Razi to kya karega Kazi. Literally, you are Mia Bibi and
Absolutely,
we are the Kazi.
Yes,
So
yes.
And I am standing ready with the amount.
Time of first
But
motion,
kindly
he has
also.
Now it will become a loose motion if you repeat.
she
Go on.
received already 7.5 lakhs.
You have said half, then you say 7.5 lakh, then you'll give the number of pieces. Same thing you're
Minus
repeating.
7.5
We
lakhs.
understand that. Are you so blunt? We look blunt, but we're not actually that blunt. The present appeal has been preferred against an order whereby the application of the parties, comma, who are spouses, comma, under section 13 capital B of the Hindu Marriage Act was dismissed for default. Full stop, next para. Learned counsel for the respondent wife, comma, at the inception, comma, takes a preliminary objection as to maintainability of the appeal, since according to the respondent, comma, the only remedy before the parties would be to take out an application under Order 9, Rule 9 of the Code of Civil Procedure. Full stop, next para. In substance, comma, there is the respondent is justified in so arguing, comma, since section 2 of the Code of Civil Procedure specifically excludes orders of dismissal of a suit for default from the purview of a decree, comma, thereby denuding the appeal from its maintainability, Full stop, next para. However, comma, since it is submitted by learned counsel for the respondent wife in the same breath, comma, on the query of court, comma, that the respondent wife is agreeable to proceed with the mutual consent divorce subject to the appellant husband paying the balance alimony amount as agreed between the parties, comma, we deem it unnecessary to relegate the parties to a further proceeding. Full stop, next para. Since the present appeal is technically not maintainable, comma, we convert the same to a revisional application under section 115 of the Code of Civil Procedure, comma, as the order, comma, if passed in favor of the appellant stroke petitioner, comma, would have the effect of finally disposing of the proceeding under section 13 capital B of the Hindu Marriage Act. Full stop, next para. Accordingly, the appellant is directed to file a formal revisional application in appropriate format for the office to keep the same on record. Full stop, the office is also directed to allot a fresh number, fresh CO number to the appeal by treating the same to be a revisional application. Full stop, accordingly, we convert the appeal to a revisional application. Full stop, next para. As both parties agree that they are willing to proceed with the section 13 capital B application for for divorce by mutual consent, would you like to come back to this court?
No, Lordship, if it is not, if your Lordship be concluded this one, that will be the complete justice.
So we are keeping it pending then.
My lord, kind does.
We fix the matter on April 30, 2026 to be listed under the heading to be mentioned. Full stop, next para. Mr. Banerjee, you pay the amount in the meantime.
My lord, I'm ready and willing.
The respondent husband shall pay the balance amount out of the total amount agreed as permanent alimony by the respondent husband, comma, to the, appellant husband, comma, to the appellant wife before the returnable date, and file a receipt in that regard on the next date of hearing, full stop, subject to such payment being made, comma, this court shall pass necessary orders disposing of the matter by granting divorce by mutual consent. Full stop, the steps directed to be taken by the office shall be undertaken in the meantime, comma, as expeditiously as possible. Thank you. You immediately, Mr. Banerjee, by tomorrow try to do it. If you cannot, by Monday. You file a proper application, give a copy to Mr. Patra.
Yes.
My lord, my lord, my lord.
And
my
just
instructions
leave
are
the
that
office. You have already done.
Lordship?
No, I'm sorry.
Instruction?
My instructions are that I'm ready, standing ready with the matter, standing ready with the balance amount. So I can pay it off by 2-3
Pay the
days.
amount immediately. Pay the amount
Yes,
immediately.
yes,
File a formal
yes.
revisional application so that the appeal
My
can
lord.
department can take steps. After you file the revisional application, it is due to come to the regular court. Please take steps for informing the office of our order so that that is not put in, or make it an application in connection with the appeal.
My lord.
Previously, we used to file alternative revision applications, application in the revision format, but an application
My
in
lord.
connection with this appeal. So a CAN number is given, office will treat that to be a revisional application.
My
You
lord.
you
My lord.
take
I have
instruction
followed.
from some senior who
I shall. I
has
will
practice
have
in
to
the
and I shall.
in the
My
civil
lord.
bar, so you'll get that
My lord, I
instruction.
shall. I will have to and I shall, my lord. I'm so very
Yes,
much grateful, my lord.
yes.
So very grateful.
We'll come back and take the next.
Yes, my lord. I am for the appellant, my lord.
What is the matter about? If it's
Matter about my
a
lord.
longish matter, we won't take up in this bench.
My lord, kindly, I am handing over my your lordship the indulgence. The short note of the if your lordship think this is a long matter, then I will not proceed.
Give 2 copies at least. There are 2 judges you are giving.
I have received brief only day after yesterday, my lord.
We have received only now.
Yes.
So
Yes.
1 copy won't.
No, it is. I am very sorry. Beg to be apologized, my lord.
The other side is also not there.
Other side is also not there. Whether
You keep it with you. We bring 2 copies on the next day. We'll take up in the regular bench.
much.
Since none appears for the respondent at the time of call, although the appellant is represented, and the regular bench is not sitting today, comma, let the matter stand adjourned for the day.
34.
34, I am for the petition, appellant lordship.
Regular full-fledged appeal.
Full-fledged appeal.
Not today. Just not today, Coach.
I am
Order record, Coach. Not today.
Miss Monica Roy is appealing for the Food Safety Authority, Lordship. Her mother got hospitalized.
Whose
this
mother?
morning. My senior's mother.
Who is your senior?
Miss Monica Roy, who is appealing for the respondent here.
No difficulty. Whenever it's convenient.
Kindly accommodate Lordship for at least 1 day.
There is an interim order given to us, my lord, till the final disposal of the appeal.
What is this CRA in connection with? Oh, yeah, actor appeal.
This is that food safety.
Food safety act.
The Moina Ghosh, my lord, is leading me.
Yes, yes. So we are making adjourning it for the day. In any event, the regular court is not there.
No difficulty, my lord.
Thank
When
you.
would your lordship be pleased to fix this, my lord?
We are just making it not today. I'll be there in circuit for 2 weeks. So next it will be taken up on 30th of April.
Very
That is the next. By default, that is the next.
Grateful.
An adjournment is sought by the respondent. Moreover, comma, the regular bench is not sitting. Accordingly, let the matter stand adjourned for the day. Adjournment is sought for the respondent, comma, although the appellant is represented through counsel.
Great.
Number 36.
My lord, I am for the appellant in this matter.
Longish. You are appearing means it will take some time. Must be some point of learning.
Yes, yes.
Although the appellant is represented, comma, none appears for the respondent, comma, nor is this the regular bench. Accordingly, let the matter stand adjourned for the day.
It's been around 30th April.
Yes, by default, yes.
37.
37. I am for the appellant, my lord. In the term of your lordship, direction notice have been served upon the respondent. This matter is related on operation bank account of council where your lordship is in terms prior made on the application by respondent for operation.
Spare yourself the trouble. We are adjourning it for the day. You are ready to move the appeal?
Yes.
But the regular bench is not there. Did we finished? Who is for the other side?
My notice I have served.
Despite notice, none appears for the respondent, although the appellant is represented today. However, comma, since the regular bench is not sitting, comma, we do not intend to keep the matter part heard and adjourn the same for the day. Come back on 30th of April. The regular bench will be sitting on 30th April. Please come prepared. You are filing the notice in court?
Yes.
File that notice. The affidavit of service, bracket notice, filed today be kept on record. On the next day, remind us that you have already given notice.
Okay.
I'm the appellant, man. If my lord deems fit, I can start today itself.
Don't start today. If it can't be over today, then don't do it.
Then my lord keeps it at any date, my
We
lord.
just adjourn for the day on the ground that the regular bench is not sitting.
Only thing I'll point out, my lords. Only thing I'll point out. Thus, there is another litigation between one of the branches in the family on the same suit property, which came up before the division bench comprising by Justice Mantha, decided by him. An SLP has been preferred. And there is a status quo order on the suit property in regards to the SLP. Now, Lordship, currently the status of that branch is also pending adjudication before the Supreme Court. And the suit property stands preserved by way of the apex court order. In the light of the
That is
same,
not
if
a
you wish to
separate cause
proceed,
of action, my lord will kindly
just to put it to your notice.
This is against refusal of injunction.
This is against
refusal of
39(4) being allowed.
So you say it's already protected, the property.
By the Honorable
That's
Supreme.
not in their control. It depends on that.
Yes, I just wanted to bring this to my lords.
We have sought to intervene,
Yeah,
but the
in the event
intervention
we are-
has not
in
been
the
allowed,
event,
my lord.
Since we are adjourning it and we can't take it up before 30th of April, let us see the
Absolutely.
outcome. Remind us on the next day when the
Absolutely.
today we'll take it up on ourselves because the regular bench is not. So
No,
actually that is a reason.
Absolutely.
Since the regular bench is not sitting, we do not want to we do not intend to keep the matter parted and accordingly adjourn the matter for the day.
Grateful, my lord. Grateful.
Should I beg to appear for the respondent, my lord, being led by Mr. Parthopratim Rai?
You are making it not today. Both of you are appeal. What is this regular appeal? Injunction appeal.
My lord, the brief is also with him.
Brief is not with.
My lord,
Well, we are just making it today. Ms. Degosh, yes. We are not recording anything, just making it not.
much obliged.
Item 39.
Not today.
Lordship, there was a direction upon us to serve the paper books, to file the paper books on the law.
Whenever you take a point out that you have served, if you have served, you point out on the next day that you have served.
Okay.
40. I appear for the there's a declaration with regard to Bhakchashi Borgadar. We have served the private respondent at recent notice, which is yet to be, the track reports are yet to be obtained. Let it be.
To enable
State is appearing.
State is appearing, yes. To enable learned counsel for the petitioners to apprise the court as to the outcome of intended service of notice on the private respondents, let the matter stand adjourned for the day.
I'm grateful, ma'am.
On the next day, we can't take it up before 30th, so you come prepared with your
Yes, ma'am.
affidavit of service.
Yes, ma'am.
Even if not served, prepare an
Yes, ma'am.
affidavit.
I have the track reports, but it's not updated.
Oh. Do whatever you have to do.
Yes,
Wait for some time.
Yes.
Before 30th, you prepare a current thing.
Yes.
41.
Similar.
Same order.
No, different matter, but similar circumstances.
The order will be the same.
Order will
That
be
is
the
all
same.
that is
The
important.
order will be the same. We have served a recent notice since appearing for hearing.
In 41, I'm not for the state, Lordship. In
You're not for the state.
In 41,
Mr. Gali was
Give your
appearing
name.
for the state.
You are not recording the state's name.
Lordship, in 40, I'm that Mr. Gali.
40, give your name.
In
41, don't give your name.
So, Mr.
You have not
Gali
recorded anything about the state. You have said to enable them to ascertain the outcome of the
in
service.
40, can I get Mr. Ghalib's name?
Is he in court? In the court?
Court,
Yes.
court
Then give
level.
his,
41, Gali, Mr. Gali.
Mr.
give his name. Give his.
I'm grateful, ma'am.
Not today. Same. Same.
I beg to appear for the matter by look for this voluminous, but this pertains to, my lord, my land being vested in a proceedings under 14T3 read with 14M and 14S. One of the contentions raised by us in this petition was one of the Mujas is an
So for the respondent,
petitioner.
here before us. Oh, this is a tribunal appeal. Yes.
That was, my lord. So one of the arguments raised
You are
by
for
us-
the other side.
No,
With you.
One of the arguments was Mouja Baluria is an urban agglomeration, my lord. That would fall under the, my lord, ambit of ULC Act. If that particular portion of land is taken out, my land
Within
would fall within the
No,
same.
no, is there any existing interim order passed by this court?
There is an interim order, my lord, wherein, my lord, status quo was directed to be maintained, my lord.
Till
and the-
disposal?
Till disposal, my lord.
Well, no
That
further
is a problem, my lord, which we are facing because, my lord, today, my lord, the prospective buyers who we have sold the because there's a, my lord, property raised, my lord, several flats, my lord, have been sold, my lord. The conveyance cannot be executed because of the, my lord, status quo order, my lord.
They are not appearing today. We will record that they are not appearing. We are appearing. Don't appear.
I am appearing.
Which means
Led by Mr.
we are
Banerjee.
not interested. So, Mr.
Please,
Banerjee, we are
please
recording
record
that
once.
they are not appearing to the respondent.
You
You
set
give a-
them ex parte. I'll give them notice and kindly also mention if they don't come, it will be set apart ex parte. Otherwise, what they are doing is every time the matter is taken up before an honorable division bench, it matures. Thereafter, they disappear.
Who's
Then
appearing for them?
last কে appear করেছিল ওদের হয়ে দেখো before Justice Boshak the matter appeared twice. All of them have changed. Mr. Galib, Mr.
Supratim Dhar, Soumitra
Supratim Dhar.
তারপরে
Then Mr. Siddiqui was appearing.
different people are appearing.
Different people are
They give a
appearing.
notice. Give a notice. Although the petitioner is represented, petitioners are represented before us through counsel. None appears for the respondents at the time of call. Full stop. The learned advocate on record for the petitioner shall give a notice indicating that the matter shall next be taken up on April 30, 2026. Full stop. It is made clear that in the event the respondent does not turn up on the next occasion when the matter is called on for hearing and/or seeks an adjournment, ex parte orders may be passed in the absence of the respondent. Full stop. The petitioner shall file a receipt of the notice on the returnability.
সব জায়গায় দেবে, জিপি সাহেবকেও দেবে।
Sorry to interrupt. 44, I was in toilet. I couldn't reach.
44? কি হয়েছে?
44 কল হয়নি তো কোথায়?
Not today. Remain in the toilet for the rest of the day.
বস সেদিকে পেটিয়া ওটালে বড় ভাই না ছোট ভাই সুগারের চাপে
Yes, next.
Item number 46.
Not today.
54.
55, 55, the 54.
50, 55.
50, sorry, 46 to 53.
That is already not today, made not today. You did not respond.
Sir, I'm just-
That has been made not today. 55 who is appearing?
Sir, I appear for the respondent number 3. I am suffering an interim order by an order of the
You should go on suffering till 30th of April at least.
last chance was given.
Last chance was given. देखिए एक बार file the file.
Interim order till disposal. 26 August 2024. Can I show that from here?
If Justice Chaudhary agrees, then only.
No, question is interim order is till disposal.
ওখান থেকে দেখাবে কিনা সেটা আপনি
No, interim order is there on your submission is sufficient. That is not necessary.
Yes. There comes the interim order.
Anyway, it cannot be taken up and concluded today.
That's the last chance. I am waiting.
You're appearing for the.
No, Lordship, I'm just waiting. If my
Your matter has been dismissed for default.
no, Lordship,
In this matter,
46 onwards, 8 matters.
we have passed some adverse order against you, probably. Just take up with it.
Not today.
That's an adverse order because your name has not been recorded. We have not passed any order. We have not recorded it. Just made it not. Yes, last chance.
Last chance. I showed the interim order. It's in effect. Good, stay with that. State has agreed. Everyone has agreed, and he has a without contiguous land.
As we are unable to take it up.
Need it.
Will be as the last year.
Really, did you know it? No? At order name.
Yes. Mr. Ghosh Lanet, counsel for the respondent is present. None appears for the appellants. By order dated 26/8/2025, an adjournment was sought on behalf of the petitioner, and it was made as the last chance to argue the matter. Top. Today, none has appeared on behalf of the petitioners. However, as we are unable to take up this matter, and the matter will be appearing
Since the regular bench is not.
since the regular bench is not sitting, let this matter appear before the regular bench on
April
30th April 2026. However, this will also be a last chance for the petitioners to appear in the said matter. Learned advocate for the respondent is requested to intimate the other side by notice.
Respondent number 3.
Respondent number 3 is requested to intimate the other side by notice.
Perfect. ফাইলটা আর বইটাও সরিয়ে নেবেন আরবান ল্যান্সিং পোকাটা পোকা সাংঘাতিক পোকা কিন্তু তাহলে জীবন কোডটা কিন্তু আর বাঁচাতে পারবে ওটা আমাদের দিকে আসছে বা নীল
কোডটা কি মানে পোকাটা খুব খারাপ ডেঞ্জারাস?
পোকাটা খুব ডেঞ্জারাস সিভিল কোডের পোকা তো যা হবে ফাইনালি ডিক্লেয়ার করে দেবে রাইট টাইটেল ইন্ডেক্সটা
ওরা তো দেখে ফেলবে।
আমরাও তো তাই ইয়েস
56, my lord, I beg to appear on behalf of the petitioner, my lord. Mr. Day is opposite, my lord, in this matter, my lord.
For the
Petitioner, my lord. Mr. Day is appear. Yes, my lord. Mr. Day, Chandicharan Day is appearing, my lord.
For the other side?
For the state, my lord. It is WPLRT matter, my lord.
WPLRT of the state.
No, no, my WPLRT.
That is what
My
you are asking.
WP.
So there is appearing for the state. That is.
Yes, Mr. Dey is appearing for this. My lord, very short issue, my lord. RS record did not disclose that factory was there.
None is
So
there.
if-
For the state, Mr. Patel. That is a difficulty.
My lord, the most senior citizen, my lord, is suffering, my lord. My lord,
None appears for the respondent state at the time of call, although the petitioner is represented through counsel. For sub next parallel, counsel for the petitioner submits that there is grave urgency due to the advanced years of the petitioners. For sub next para, be that as it may, comma, since the state is not represented, comma, we adjourn the matter for the day. Full stop. It is made clear that in the event the respondents are not represented on the next occasion, comma, the ex parte orders may be passed in the absence of the respondents. Next.
grateful, my lord.
My lord, I beg
Yes,
to differ on behalf of the petitioner, my lord, affidavits have been exchanged, my lord.
Who is appearing for them?
My lord, Tarok Koran and Mr. Shishanno Bandyopadhyay. My lord,
Shishanno Bandyopadhyay is
probably will
no longer interested in courts.
But Tarok Koran has affirmed the affidavit and my lord, it has been exchanged. My lord,
Tarapon
will
should
you-
be here. We don't know. We are passing a similar order as the previous one.
My lord,
Last chance to them.
much.
Same order. Goes. If you can give a
My lord, I will give. I will
third
serve
copy
them
at least.
because 30th April it will be appearing again.
We are not saying 30th April.
But I will be getting. I will be getting something. Much okay.
And you can just serve a server copy of this order so that they know this is the last chance.
Much okay.
Not today.
Wait, Lord.
For 59, my lord, we are appearing behalf of the appellant, and my lord.
What about the other matters? You are not for the petition.
No, the other matter, the state has appealed.
Same.
My lord, the same matter, same order.
The other respondent 62.
Can we dispose of today itself?
Well, only short point, my lord, cut-off date. Your lordship's earlier occasion raised. Cut-off date says when the death of the riot. My lord, that 2002, but 15/2/71, this is a cut-off date.
Yes, who is appearing for the state?
Lordship, in the WPLT matter,
No, here. Who is it?
for the appeal, Lordship, for the
All state is the other side in all the either the appellant
one
or
matter, Lordship, Mr. Galib is there and I was the junior Lordship in other.
so you are here. So let us hear it
The
out.
other matters, Lordship, Mr. GP is leading the matters, Lordship.
Where is he?
Lordship, the short passover, then I'm Lordship just.
We are passing it over. Password. Atta matter password. 2 p.m. Should we keep it at 2 p.m?
Yes, yes, ma'am.
Password থাক কোথায় আবার আটকে যাবে এই ঝামেলা করে we are passing it over for the time being আচ্ছা এটা tribunal after the tribunal applications are over we will take up this matter we will take up 2 passover matters হ্যাঁ সে ঠিক আছে ঠিক not today sir not
63, my lord. 63, my lord. I appear for the my lord respondent. It is the application filed by the state, my lord.
make it not today today the regular bench is also not there Mr. Vita. So we are making not
Yes, my lord. Some urgency, my lord, can
What is the
taken up.
urgency?
My lord, the urgency is, my lord, the tribunal allowed the application and contempt is pending, my lord. There is an interim order passed, but the interim order has not been yet, my lord, extended. But still, my lord, we have allowed tribunal allowed the application and also review the dismiss the review also.
Oh, petitioner নেই তাহলে আর কি করে
So, Lordship, I think this is not the 66 item, this is the 56.
36, 60, 63, my lord.
63, he's saying about 63.
you are too late in
63,
the day Mr. Betal 66
My
to
lord,
68
I have connected at 63, but my lord, perhaps, my lord,
we don't run by your connectivity time
yes, my lord.
we run by real time
I was
6 to 68 you are for respondent
Respondent number 6.
so we are making not today then what can be done 69 এখন তো পাসওয়ার্ড গুলো হবে
My lord, item number 30, my lord, I am appearing on behalf of the plaintiff, appellant, my lord. My lord, the ground is, my lord, this is a partition suit, my lord.
30 to 71 বোর্ডে দেখান ও তাই বল yes what is the is it against an injunction order or
Yes, my lord. Yes, my lord.
who is for the other side
Well, we have served, my lord. This is affidavit of service, my lord. But the other side,
Can it be done during by today? What is the what is your ground in the appeal?
Lord, the partition suit. Lord, the partition suit has been filed by the respondent. But the ground is, but the partition suit which the respondent is claiming, this is my property. All the deeds are my name, my lord. But in spite of the same, they are claiming that this is a Benami property. This is a property of my father, and they have filed the partition suit, and the court below granted the injunction order, directed the parties to maintain status.
Benami bar is your first point.
Yes.
Benami, this does not fall within those exceptions.
Yes.
Those relations.
Yeah, my lord, one more thing, my lord.
No, does it fall within the exceptions? Benami Act has certain
Yes.
If it falls within the exceptions, it is not barred by Benami. Then.
If my lord will kindly see the last order. My lord, the point is there are 3 deeds. All deeds are in my name.
No, injunction was a contested order or admitted?
Contested order.
Okay. So there is an order of status quo.
Status quo.
What are your points? One is delay.
Yes.
They are delay.
No. My lord, the point is, my lord, the status quo was granted on the point that this is a partition suit. That is why till the disposal of the suit, party should maintain status quo. My point, my lord, in the suit, there are total 4 properties. In respect of the Schedule A property, my lord, the separate suit was filed. Even in respect of Schedule A property, there is no dispute. I am also accepting this is a property of joint property. Let it be partition. But in respect of B, C, and D property, my point, this is my personal property. This is not a property at all.
It's an arguable question. This has to be decided in the suit.
No, I will satisfy to your lordship in respect of all the documents. It will show to your lordship that this is my personal property.
No, they're admitting it's in your name.
Yes.
But all the that, but saying that they have made out a case that it's Benami purchase out of joint nucleus.
But the business, all things are in my name. Even the business which the respondent is saying, all are in my name. So there is no question of
in your name, but his case must be that it is purchased from, it is financed by joint family nucleus property, nucleus funds.
If my lord will kindly see the
It's an arguable question. Why should he conduct a minute trial?
Balance of convenience and this irreparable loss, nature of the suit.
I absolutely agree with him. My lord, if your honor, if my lord will kindly see the last order, my lord. 27 January 2025.
Our order?
Yes, ma'am.
27 January.
My lord has admitted the appeal and directed us to serve a copy.
So trial court records need not be called for. কেউ অ্যাপিয়ার করছে না রেসপন্ডেন্টের হয়ে
নোটিশ দিয়েছে বলছে
তাহলে লোয়ার কোর্ট রেকর্ডকে অ্যাডভোকেট ট্রায়াল কোর্ট রেকর্ডকে সার্ভিস করে দিই তাহলে তুমি ট্রায়াল কোর্ট রেকর্ড
না আর দরকার নেই সার্ভিস করেছে যদি না আছে ওদের চয়েস তারা 2 আর 3টা দেখুন ফর্মুলেট করা নেই shows the impugn order.
Yes, madam. Lord, one more thing, Lord, we have filed CAN 2 application.
What is that for?
Lord, the CAN 2 application is for the addition of the party. All the cost title which is in the suit, some of the party has not been included. They are the pro forma respondent. That is why, my lord, we have come with the CAN 2 application. I have seen the memorandum of appeal. There are all the parties' name has not been included.
So we're allowing that to incorporate the names and serve notice on them also.
I will. I can.
তাহলে ওটাকে অ্যামেন্ডমেন্ট করতে হবে বিকজ
লিভ দিয়ে দিচ্ছি CAN 2 টা অ্যালাউ করে দিচ্ছি CAN 2 of 2026 is an application for addition of parties which the
affidavit of service.
Parties sought to be impleted, comma, it is submitted by learned counsel for the appellant, comma, were parties in the suit before the trial court but were omitted bona fide to be arrayed as parties in the appeal. শুনুন ওখানে রাখবেন না এখানে রাখুন উপরে accordingly, comma, we find that the said parties are necessary for proper adjudication of the present appeal. So accordingly, CAN 2 of 2026 is allowed, thereby directing the parties sought to be impleted therein to be added as parties to the appeal in terms of the prayer made in the application. The learned advocate under court for the appellant shall carry out the necessary corrections to the cause title of the memorandum of appeal accordingly during the course of the day. Copies of the amended memorandum of appeal and Can 1 of 2024 shall be served on the added parties, and a further affidavit of service in that regard shall be filed on the returnable date. Full stop. The matter shall next be listed under the same heading on April 30, 2026. Affidavit of service filed to be kept on record.
I'm also filing the main affidavit. There are two affidavits of service.
What is this?
First
Affidavit of service.
Yes, I'm grateful.
Possible item number 59 to 62.
Yes, Mr. Mukherjee, what is that? On the last occasion, none of you appeared.
Not.
On 1st of September, none of you appeared.
Well, kindly see the order dated 16th June.
The Ghalib and all, where are they? I mean, they were appearing in the last service. Mr. Ghalib is a regular otherwise. Must be engaging. Should we take up the matter expiry? Tomorrow they'll file a recall application again. That is what we were wondering.
Well, kindly see the order dated 16/6/2025.
16/6.
2025.
Hey. Oh, certain particulars. They have not yet furnished the particulars.
Then kindly see the report. Report says the cut-off date that is on 7/3/2000. Report kindly see the report which was submitted by the state. They specifically stated that clause 3, Roman 3, the point, the cut-off date of determination of ceiling is 7/3/2000.
Report
page.
This is that report. This sort of.
This is the report.
Just reverse it. Show us from there.
Yes.
Now turn. রিপোর্টটা খুঁজে দিন কোন রিপোর্ট করছেন দাখল ওনাকে দেখুন পেলে এটাও নিয়ে নেবেন
এটা এখান থেকে শুরু হচ্ছে
ল্যান্ড রিফর্মস একটা দিন রুলসটা দিয়ে রেখে দেওয়া ভালো দীপঙ্কর ওনাকেও দিয়ে দিতে হবে দিতে বলবো স্টেট থেকে না আপনি একদিন তো এডুকেশন ইন্টেরিয়র ওয়ার্কেশন কিছু আছে আর কি যেটা ইন্টেরিয়র অর্ডার এটা জিজ্ঞেস করে নিচ্ছি কারণ এটা রিপারকাশন হয়ে যাবে পরেই দেখে দিল Mr. Mukherjee, we would like to hear the state on this. Are you enjoying an interim order?
Yes.
না ইন্টারিম অর্ডার আমাদের কোন
আমাদের ম্যাটারটা অ্যাপিলটা
না আমাদেরটাই কোনো স্টে নেই স্যার আমাদের এখানে খালি আমাদের মানে তো
There is no scope of stay. Is there a scope of stay?
There wasn't an interim order which was passed. Interim order to pass. Interim order আমাদের
We are keeping it on 30th when the regular bench will reassemble.
That land treating as a vested land because the only
Yes, we are making it clear in our order that they don't because on the last occasion none of you appeared. That has been recorded. So we have to give them one more chance. And this may have repercussion in other matters also. That's why you are none appears for the respondent state even on the second call. Although the petitioner is represented before us, who's of next para, as a last chance to the respondents to argue the matter, comma, let the matter stand adjourned till April 30, 2026. Whose it is made clear that in the event the state remains unrepresented on the returnable date, comma, the matter may be taken ex parte in the absence of the state. Whose next para? A server copy of this order shall be served on the learned advocate for the state by the learned advocate on record for the petitioner. A server copy of today's order for the petitioner in the meantime, and a receipt in that regard shall be filed on the returnable date. Serve them a notice and reference এখন থাক, অন্য ম্যাটার লাগতে পারে, আবার বারবার যাবে আসবে। নেক্সট, না এটা তো আপনার এটা ওদিকে গেছিলেন।
I am appealing in this matter, my lord. Mukherjee, Paul Mukherjee, in this matter, just given short passover, my lord.
Short passover?
Yes, my lord.
Very passover.
এই তো ক্যাভিয়েট না থাকলে কোনো ব্যাপার নেই।
হ্যাঁ, এটা শুনে নাও, passover করে passover। অর্ডার করতে হলে তো কোনো ঝামেলা নেই। ওগুলো অ্যান্টিসিপেট করতে পারেন, এতগুলো হয়ে গেল।
তাও তো ডিসপোজাল হতো হলো।
হ্যাঁ হ্যাঁ,
বড় ম্যাটার ডিসপোজাল হয়ে গেল।
passover, এগুলো ফার্স্ট কলে passover করব।
My lord, I appear for the appellants in this matter, my lord. In this matter, we had filed an application seeking leave to appeal because I was not a party, and I was saying that this was a collusive suit. Mr. Bachawat was leading the arguments. Mr. Sinha, I believe, on the last day, Lordship was minded to grant us leave to appeal, but Mr. Sinha had some arguments to make.
Yes. What can be done in their absence? Probably today the people won't be anticipating that the list would be called so far.
I guess, my lord.
I guess that. You are passing it over in the first call, second call will consider.
Much obliged, my lord.
If you can intimate them, the other side.
Very
In
well,
the
my
meantime,
lord.
we are not passing an order.
We will
It's
intimate
passed
them,
over
my lord.
in the first call.
পরেরটা তো পার্ট হার্ট 76
Part heard.
My lord.
Not today.
But the
We'll record an order. Since the regular bench is not sitting and the matter has been heard in part by the said bench, comma, let the matter stand adjourned for the day.
My lord, I am being led by Mr. Bachawat. He is not available till 17th, so it can be posted
17th of?
17th of this month.
We are not available till 30th of April.
Then
the 30th,
30th will be the next.
before that, my lord, no, this is, my lord, order 41, so your lordship will take it. Your lordship
No,
will be back 27th.
29th.
Oh, grateful.
After 28th, we have circuit court.
Grateful.
So you can move it. It will be in the list.
Very good.
We are keeping it in the list.
Very
We are not adjourning till 30th.
Because
Oh,
of the-
part heard matter we can.
Yes. Grateful.
Passover first call. Same. Passover first call.
My lord. This is the petitioner. A condonation application is pending. The copy has not been served. That's a give me an opportunity to serve the copy of condonation. 80 and 81. 80 and 81.
এটা সব করে দিতে হবে। যাতে যখন হবে তখন কন্ডিশন অ্যালোকের সঙ্গে সঙ্গে স্টেইনলেস তো আবার একটা দিতে হবে। করা যায় এক্সেপশন না হলে করা উচিত না। What is the delay?
One is 19 days, another is 59 days. 80
There
and
are two appeals.
2 appeal. 80 and 81.
80, 81 একসময় বোর্ডে দেখেন। These arise from the same matter.
Here arising from the same matter.
The appellants shall serve copies of Can 1 of 2026 and Can 2 of 2026 in connection with both the appeals on the respondents, indicating that the matter shall be listed under the same heading on April 30, 2026. Sorry, April 30. On May 5, 2026, when an affidavit of service to that effect shall be filed by the appellant.
Get Lordship.
In both the appeals, please serve copies.
Yes.
In both the appeals, serve
Yes,
copies
yes,
and file
yes,
affidavit
Your
of service. Given names.
Lordship, the appellant is the plaintiff. Lordship, there is a delay of. This is an.
Have you served on the other side? This is the first time.
First time, 31 days delay.
For the first time
First
appearing.
time. And Lordship.
Then
this
you
is
serve copy and
against the-
have to
Lordship,
serve copy.
refusal order of identity order of
But condonation is there. The appellant shall serve copies of Can 1 of 2026 and Can 2 of 2026 on the respondents 1 to 3 only.
Yes.
Respondent
Then the pro forma also 4 to.
No, you have sought for relief against only 1 to 3.
No, also 4 to 6.
On the respondents as well as the pro forma respondents, indicating that the matter shall be listed under the same heading on May 5, 2026, when an affidavit of service to that effect shall be filed by the appellant.
Also the application for stay also.
Both, serve both because to cut short time. If we allow the condonation, then we'll immediately take up for order 41.
Grateful. Proceed. May it please, Your Lordship.
Yes.
For the respondent.
Respondent, then you cannot please us. Who is for the appellant? Pass over in the first call.
There was an application for substitution that has been taken out by.
Pass over in the first call. We'll take up in the second call.
Already 2 minutes.
Yes.
And we have solved.
There's a caveat.
There is caveat, man.
Yes, Mr. Dr. What is that?
This is very short point in part. Against an interim order of injunction in a suit for specific performance of contract, admittedly unstamped and unregistered agreement. And before that, Your Lordship kindly consider these are the legal questions, my lord. The Supreme Court judgment I have brought, Your Lordships also dealt with this matter, and my lord, both of our Lordships are dealt with the matter. This unstamped agreement, unregistered agreement on rupees 10, they have averred that there was oral agreement, this memorandum of understanding, that memorandum of understanding is not enforceable. And apart from this, my lord, this person, my lord,
No, Mr. Dotto, oral agreement, if there's a written agreement, then it is required to be stamped registered first. Secondly, under section 49 proviso, it is not required to be registered if it's if you're relying on that in a specific performance suit. There's a proviso to section 49 which lays down an exception.
My recent Supreme Court judgment, my lord, says that even collateral purpose cannot be used as. Your Lordship kindly consider, apart from this, my lord, my averment in the stay application, Your Lordship kindly consider. My paragraph 2, Your Lordship kindly consider.
Your stay application here will not make a difference. What was before the trial court was.
No, my lord,
It is an ad interim order.
ad interim order, my lord, I will be confined with in respect to the plain. In the agreement, my lord, I believe that all documents as filed by, my lord, this is a big plot of land. Admitted position, there are 7 person co-sharers. My lord, 7 person enter into agreement with another person, and 6 person already transfer the property to another person, and he is in possession in respect of the entire suit property. And my lord, there was an order of ad interim order of injunction not to change the nature and character. If the property is undivided property, the possession has not been delivered, and if there be any injunction not to change the nature and character, then there will be the property is holding other person. We have delivered possession. Sale deed executed.
As of the status quo will be as on the date of the order, from that date onwards. Why shouldn't there be a status
not status quo, my the specific order, then not to change the nature and character of the suit property.
What is the difficulty in that? But the nature and character is changed. Then
already, my lord, this property is holding by another person. See, there are 7 co-sharers. Well, six.
They are not bound. You have been directed to maintain.
Well, this is undivided property. Already, this person also entered into agreement with another person. That's why, in their
It's all the more necessary then that gives rise to the urgency to get an injunction.
But
You have entered into an agreement.
Anyway, all these are to be decided in contest before the trial court.
Right, Your Lordship, my lord, Your Lordship kindly, I will argue on the point of law first, my lord, Your Lordship kindly consider this.
এই registration একটা দিন তো আর stamp একটা করলে there is a proviso to section 49.
My lord, unstamped unregistered agreement.
That is what you please read the proviso to registration act section 49.
দাও 2025 দাও
Section 71 the registration act টাকে কনসিডার করেছি পরে এটা বলেছে
মানে 2016 ফার্স্ট Your Lordship kindly consider দুটো দাও
রেজিস্ট্রেশন একটা দিন একটু
আমার বুঝুন আজকে আছে বুঝতে পারিনি যে টা দাও
রেজিস্ট্রেশন একটা আছে এখানে আচ্ছা দেখিনি এখানে
Non-registration of documents required to be registered.
দুটো দাও আরেকটা দাও আমারটা এখানে আছে
Proviso-টা দেখতে
তোমার কাছে ছিল তো এটা তো আমারটা
expressly bond, expressly comfort তখন সেটা কনসিডার
my lord, place my lord, Your Lordship, my lord. 2016, my lord, volume 2, CHN, Supreme Court, my lord. Paragraph 15, 18 and 16, 15, 17 and 18. My lord, paragraph 14, Your Lordship kindly consider regarding Registration Act. Before we go into the merits of the matter, we deem it appropriate to extract the relevant provision of Registration Act 1908, Section 17. The document of which registration is compulsory. The following documents shall be
the partition suit, Mr. Dotto.
No,
This was a partition suit.
Not at the injunction.
Next, my lord, Your Lordship kindly consider section 49.
See the proviso, read the proviso from there. This was in a partition suit. You were in a suit for specific performance.
Specific performance, my lord.
Please read the proviso from that, Mr. Dotto. Read it out loud. It's been quoted.
All right, my lord.
Para 14. Read the proviso.
My lord, I am reading entirety, my lord, Your Lordship. The following documents shall be registered if the property to which they relate to.
No, we are asking you to read section 49. It has been quoted in.
Yes. Instrument, gift, immovable property, other non-testamentary instrument with purported.
What are you reading? Where are you reading?
Yes. Come to third page of the judgment.
Immediately before para 15.
Para 15, yes, ma'am.
Before that, section
Before
49
that.
has been quoted.
Yes, no document required by section 17 or by any
These are the documents which are required to be
Transfer
registered.
Property Act to be registered shall affect any immovable property comprised therein to confer any power to adopt or to receive any evidence on transaction affecting such property.
Please read the proviso, Mr. Dotto. Proviso.
Provided that an unregistered document affecting immovable property and required by this code or the Transfer of Property Act 1882 to be registered may be received as evidence as a contract in a suit for specific performance, Chapter 2 of the Specific Relief Act, or as evidence of collateral verification not required to be affected by registered. But then Your Lordship kindly consider paragraph 18.
This judgment is not applicable here. This was in a partition suit. It is not in a specific performance suit.
It is clearly observed in this section that the section will be bound. Clear. We are bound by the section.
Next, paragraph 18, Your Lordship kindly consider.
Mr. Dotto, this judgment was rendered in the context of a partition suit. Whatever is stated there is not applicable.
Again, my lord, another judgment, my lord, it's a judgment 2025, Your Lordship kindly consider.
It was the judgment.
Question. 2025, Volume 1, Indian Civil Cases, Supreme Court. Page বলে দিচ্ছি page 534. Paragraph 27 and 30. Head note also speaks about
radically challenges to
What is the dispute hearing? Finally, this এখানে specific performance কিন্তু dictate challenges to the dictate against labor.
my lord, may I read, my lord?
This para?
Paragraph 27.
এখানে suit শেষ হয়ে গেছে।
The agreement
Injunction stage.
advanced on behalf of the plaintiff respondent number 1 is that he would be entitled to get benefit of section 36 of the Stamp Act as the document had been exhibited and admitted in evidence, even holds no ground in as much as the document was found
Yes,
to be.
this was from a final degree passed in a suit. Till that stage, it was not corrected. That is the ground.
My lord, next,
Court says holds no ground in as much as not been removed or cured.
Paragraph 30. We find no reason to disagree with the findings of the trial court regarding the inadmissibility of the agreement to sell, dated such and such. The document being insufficiently stamped was rightly, my lord, was rightly barred from admitted in evidence in the absence of any requisite stamp duty and penalty being paid, and certified copy of the High Court in treating the document is admissible without resolving the stamp duty deficiency overlook the statutory mandate under the Stamp Act, as the document is foundational of the suit. The failure to comply with the statutory requirements renders the entire claim unenforceable. Consequently, the suit must be dismissed.
Anything else, Mr.
Next, my lord, your lordship kindly consider the judgment of 2009 to the 2009. আরেকটা দাও। My lord, 2009, volume 2, SCC, page 532. My lord, paragraph 17, 22, 23, and 24. My lord, I am placing paragraph 17 first, your lordship. The Parliament has, in section 35 of the Act, advised use the words for any purpose whatsoever. Thus, the purpose for which a document is sought to be admitted in evidence or extent thereof would not be a relevant factor for not invoking the above mentioned provisions. Next, paragraph 22, your lordship kindly consider. We have noticed heretofore that section 33 of the Act casts a statutory obligation on all the authorities to impound document. The court, being an authority to receive document in evidence, is bound to give effect thereto. The unregistered deed of sale was an instrument which required payment of stamp duty applicable to the deed of conveyance. Adequately stamp duty admittedly was not paid. The court therefore was empowered to pass an order under section 35 of the Act. Next, my lord, your lordship kindly consider paragraph 23. The contention of the learned counsel for the appellant that the document was admissible for collateral purpose, in our opinion, is not correct. In such and such case, this court was not concerned with the provisions of the Act. Only interpretation of the provisions of the Registration Act was in question. It was opined. The main question, as we have already noted, is the question of continuous possession of the plaintiff over the suit land. The sale deed dated such and such, Fakir Chand, the father of the defendants, in favor of Tola Singh. The predecessor interest of the plaintiff is an admitted document in the essence in its execution is not in dispute. The only defense set up against the said document is that it is unstamped and unregistered. Therefore, it cannot convey any title to the land in favor of the plaintiff. Under the law of sale deed is required to be properly stamped and registered before it convey title to the vendee. However, legal position is clear. The document like the sale deed in the present case, even though not admissible in evidence, can be looked into for the collateral purpose. In the present case, the collateral purpose has to be seen in nature of possession of the plaintiff over the suit land. The sale deed in question, or at least shows that initial possession of the plaintiffs over the suit land was not legal and not.
This is the unnecessary. The possession is not required.
Next, you will also kindly paragraph
25.
24.
Achha, 24.
In the present case, by reasons of the statutory interdict, no transfer all is permissible. Even transfer of possession is not permissible. Such and such section 49 has been quoted for provided that an unregistered document affecting immovable property and required by this act or Transfer of Property Act to be registered may be received as evidence of a contract in a suit for specific performance of contract under chapter 2 of the Specific Relief Act 1877 such and such, or as evidence or any collateral transaction not required to be affected by if the document is registered. Next, Your Lordship, kindly consider the judgment already held that
Yes.
the judgment next
Tells Mr. Datto.
next judgment, my lord.
How many more judgments, Mr.
My
Datto?
lord,
Same proposition don't repeat.
no, not same proposition, my lord. Even my lord, Karnataka judgment. This is more, my lord, memorandum of understanding what Karnataka High Court said, my lord, recently, my lord.
How recently?
This is single bench judgment. You will also kindly consider the proposition of law.
How recently?
That High Court, my lord, said paragraph 20, 23, and 24.
Paragraph
20, 23, and 24.
Transfer property by sale is compulsory. These are a different point, Mr. Datto.
Well, this is memorandum of understanding. My lord, they are relying that oral agreement, then my lord, written agreement.
Yes.
This is not my lord, at all concluded contract. And apart from this, my lord, this is the legal question, my lord. These are the legal question. And my lord, regarding injunction, my lord, another single bench judgment I may submit, my lord, if you lordship
yes,
allow me, my lord. It is all. Chammi by.
With citation.
Paragraph 5 and 6. This is short judgment, my lord. You also kindly considered in a specific performance on unregistered agreement. That was High Court single bench, my lord, held that no injunction can be granted. My lord, paragraph 5 and 6. Paragraph 6. In the present case, the agreement to sell on the basis of which the plaintiff claimed Reliance was executing their 2023 on a stamp of ₹50. The consideration stated therein is to like such and such. The stamp duty payable thereupon was admittedly such with 50. The document is hence deficiently stamped. The same is also unregistered. Thus, on the basis of the unregistered and unregistered document, no relief, including the relief of temporary injunction, can be granted.
Yes, we're passing out order, Mr.
Apart from this, my lord, your lordship, another judgment of the Honorable Supreme Court, recent judgment, that document mark that has been also withdrawn. This judgment, Honorable Justice, my lord, Dipankar Datta, my lord, and
apart from the name, is there any other point in the judgment?
My lord, this document, unregistered document exhibited, that has been subsequently withdrawn.
How does that matter here in injunction stage?
It is leading to unregistered and unstamped agreement.
Not exhibited. Court has power to invoke.
Order now.
And my lord, one thing, my lord.
Whenever you start, no, finish your arguments, Mr. Datto.
Extremely sorry, my lord. If you lordship, my lord, not to allow my prayer, my lord, my submission, my lord, I may be permitted to contest the, my lord, within certain time.
Who prevents you? Yes. Who prevents you from contesting the injunction?
I pray before lordship, my lord.
So this is against ad interim order.
Yeah.
See, in any event, you are
decided on contest.
Yeah. If you lordship pass this order, then I may be permitted to, my lord.
You got no permission from us. But law permits you.
My prayer before lordship, my lord.
The present challenge has been preferred by the defendant in a suit for specific performance of an oral agreement for sale, for permanent injunction and other consequential reliefs. Pushed up by the impugned order, the learned trial judge granted. He is Mr. Datta. No further arguments. Please take your seat. Enough is enough. By the impugned order, the learned trial judge granted ad interim injunction against the defendant stroke present appellants and their main agent and assigns from transferring, alienating, changing the nature and character, encumbering or creating any third-party interest in respect of the suit property for a limited period. For the next para, learned counsel appearing for the appellant argues, appearing for the defendant appellant argues that the learned trial judge was debarred by law from passing such order on the basis of an unstamped and unregistered agreement. Full stop. Apart from the fact that the agreement pleaded was oral and did not give rise to a concluded contract, comma, it is contended that for obtaining an order of injunction, comma, it is mandatory that an agreement for sale has to be stamped properly and registered. Puts up in support of his arguments, comma, learned counsel for the appellants cites several judgments which we are dealing with as follows. Colon niche. The first judgment cited is in the matter of namta dekhe kore di. Namta dekhe kore di. Reported at 2016 2 CHN within bracket SC 28. Full stop. However, comma, we are unable to agree with the contention of the appellant that the said judgment is a binding precedent in the present matter. Full stop. Next para. The facts of the case as narrated therein clearly indicate that the matter arose before the Supreme Court from a partition suit. Full stop. Next para. The Honorable Supreme Court, comma, after considering Section 49 of the Registration Act 1908, comma, came to the finding that Section 17 within bracket 1 within bracket small b of the Registration Act mandates that any document which has the effect of creating and taking away rights in respect of an immovable property must be registered, and Section 49 of the Act imposes a bar on the admissibility of an unregistered document and deals with documents that are required to be registered under Section 17 of the Act. Full stop. However, comma, there is a difference between a suit for specific performance and suits of other nature. Full stop. Such distinction is drawn not by us but by the proviso to Section 49 of the Registration Act itself. Full stop. The main body of Section 49 of the said Act debars any document required under Section 17 of the Act to be registered from being received as evidence of any transaction affecting such property or conferring such power. Full stop. However, comma, the proviso thereto carves out carves out an exception thereto insofar as suits for specific performance are concerned. Full stop. The proviso stipulates that an unregistered document affecting immovable property and required by the Registration Act or the Transfer of Property Act 1882 to be registered may be received as evidence of a contract in a suit for specific performance under Chapter Roman 2 of the Specific Relief Act, comma, 1877 within bracket since amended, bracket closed, or as evidence of any collateral transaction not required to be effected by registered instrument. Full stop. Thus, comma, the proviso to Section 49 carves out a clear exception to the general proposition that documents which are required to be mandatorily registered, comma, unless so done, comma, shall not be accepted in evidence. Full stop. Hence, comma, the bar stipulated in Section 17 read with Section 49 is not applicable to the present case as opposed to the case from which the cited judgment arose. Full stop. Thus, comma, the said judgment cannot be a german precedent in the present context. Full stop. Insofar as Avinash Kumar Chauhan versus such and such reported at 2009 2 SCC 532 is concerned, comma, in the said case, comma, the Honorable Supreme Court observed, comma, on a composite reading of sections 33, comma, 35 and 36 of the Stamp Act, comma, that the court has the power to pass an order in terms of Section 35 of the Stamp Act, irrespective of the objection as to admissibility of an unstamped document being waived under section 36 of the said act. Full stop. Next para. However, comma, it is to be noted that the said matter arose from an order directing impoundment of a document. Full stop. Next para. Such stage has not yet arrived in the suit in question. Full stop. Next para. In any event, comma, before production of a document in evidence, comma, it is open to the trial court to direct such document to be impounded. Full stop. Next para. More importantly, comma, in the case at hand, comma, the document relied on by the plaintiff stroke respondent was an oral, sorry, the document, the agreement relied on by the plaintiff stroke respondent was oral, and as such, comma, in the absence of such agreement being reduced to writing, comma, the provisions of either the Stamp Act or the Registration Act cannot be said applicable thereto. Full stop. Next para. We hereby note that there is no statute which mandates every agreement for sale to be reduced to writing. Full stop. Rather, comma, the language of section 10 of the Indian Contract Act is wide enough to encompass any sort of reciprocal promises within the ambit of a concluded contract between the parties, comma, without putting any restriction regarding such contract being mandatorily to be in writing. Full stop. Hence, comma, the ratio of the judgment is not applicable to the present case in such light as well. Full stop. In Vidyut Sarkar and another versus such and such reported at 2025 bracket 1 ICC 534 bracket SC, comma, the Honorable Supreme Court was concerned with the effect of section 36 of the Stamp Act and observed that an insufficiently stamped document was rightfully barred from being admitted as evidence in the absence of requisite stamp duty. Full stop. Next para. In the said matter, comma, however, comma, the Honorable Supreme Court recorded that as the document that the argument advanced on behalf of the plaintiff that he would be entitled to get benefit of section 36 of the Stamp Act as the document had been exhibited and admitted in evidence, comma, holds no ground inasmuch as the document was found to be insufficiently stamped and was marked as exhibit with objection, and that objection having not been removed or cured, comma, no benefit of section 36 of the Stamp Act could be extended to the plaintiff stroke respondent number 1. Full stop. In any event, comma, the said ratio is not applicable in the present case, comma, which arises out of the refusal of the grant of an ad interim injunction. Full stop. It would be premature, comma, at this stage, comma, to observe that despite getting an opportunity and the document having been exhibited with objection, comma, the plaintiff did not remove or cure the defect regarding stamp. Full stop. Hence, comma, the said judgment does not carry any separate effect as a binding precedent insofar as the present appeal is concerned. Full stop. We are unable to agree, comma, with utmost respect, comma, with the learned single judge passing the judgment in Chamibai and others versus Sidnath and others, comma, an unreported judgment cited by the learned advocate for the appellant. Full stop. In the said matter, citation আছে আচ্ছা ব্র্যাকেটে ওখানে নিউট্রাল সাইটেশন নাম্বারটা লিখে 2025 MPHC block IND 5866, comma, wherein the যেটা কন্টিনিউ করো, wherein the learned single judge observed that even at the stage of temporary injunction in a suit for specific performance, comma, the document is mandatorily required to be registered and stamped. Full stop. In view of our above discussions, comma, and in the light of the proviso to section 49 of the Registration Act, comma, the said judgment does not lay down the correct proposition of law. Full stop. In Srinivas such and such reported at 2025 bracket 3 ICC 202 bracket a Karnataka, comma, learned single judge of the Karnataka High Court had held that the defendant therein was a mere holder of an agreement for sale and MOU, but these documents were unregistered ones. Full stop. Next para. However, comma, however, it was further observed that if the agreement of sale and MOU were registered, and if the defendant was claiming that he had handed over possession of the property, comma, then it could have been accepted. Full stop. Though the agreement of sale and MOU were relating to the sale deed of plaintiff, and those documents are unregistered one, comma, it cannot be presumed, comma, it was held, comma, that the defendant is in possession over the property. Full stop. Thus, comma, the premise of consideration in the said case was entirely different from the present case. Full stop. Next para. As such, comma, we do not find any substance in the proposition of the appellant that the impugned order is expressly barred by law, comma, in view of the fact that the agreement relied on by the plaintiff respondent was an oral one, and that section 49 proviso of the Registration Act applies to the said case. Full stop. Next para. Even otherwise, comma, we do not find any reason to interfere at this stage, comma, since at the stage of grant of ex parte ad interim injunction, comma, the court is only to look into the pleadings of the plaintiff and the temporary injunction application, as well as documents furnished therewith. Full stop. Next para. On such premise, comma, we find that the learned trial judge was justified in passing an order of ad interim injunction, thereby protecting the property. Full stop. Next para. Hence, comma, the appeal fails. Hence, comma, appeal fails. Hence, comma, FMAT 109 of 2026 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 1 of 2026 is also disposed of consequentially in order to cause urgency.
My lord, extremely sorry, my lord. Oral agreement and also written agreement. One line, my lord, one word, my lord, may be incorporated, my lord, along with written agreement.
Your Lordship, item number 74.
পাসওয়ার্ড করে ডেকে নিন।
My lord, kindly
না
pardon.
অর্ডার 41 শেষ হয়নি তো। অর্ডার 41 কি শেষ হয়ে গেছে লিস্ট? আমরা বলেছিলাম অর্ডার 41 লিস্ট শেষ হলে তারপর দেবো পাস।
My lord, kindly pardon. Other side is here, my lord, item number 11, my lord.
Already sent it for uploading.
My lord, due to my considering my
Which
ill
was the
health-
item number?
11, my lord.
আইটেম নাম্বার 11টা একটু যে নিয়েছি আমি সই করে দিয়েছি কিন্তু আপনি নিয়েছেন স্যার ওটা আপলোড করে দিয়েছেন তাহলে আপলোডটা করবেন না
Hello, since it was dismissed at 10:45, my junior has communicated the order at 11:30.
You file a formal
That is
application.
the only issue.
My lord,
Otherwise,
Sign the order also. Pass in open.
My lord, only consider, my lord, the my lord,
that is the only
at
issue.
least,
Oh,
my lord, 200, my lord, small, my lord, stall will be, my lord, evicted, my lord. Lordship, kindly consider, my lord. Due to my ill health, my lord, I could not reach due to traffic jam.
একটা লেটার বলে না অর্ডার করেন since we have passed an order in Copen we are recalling that you 11 এই লেটার বলে after the matter is dismissed for default comma learned counsel for the appellant petitioner দেখেন mentions the matter and expresses the reasons for his inability to attend the matter when it was called in the morning. First up, since learned counsel for both the sides are present and taking into consideration such inconvenience of the appellant, comma, we recall our order dismissing the appeal for default and restore it to its original file and number. First up, the matter shall retain its position in the list.
My lord,
Please
my
just
lord,
read debate again.
my lord, deeply obliged.
Next.
85 আমাদের তো?
Yes, what is this against?
Well, the impugned order,
yes,
has restrained me from excavating and selling. Well,
It is 193.
the impugned order is at page 192. Well, I'll just-
Not filed a certified copy as yet.
well,
We gave you leave to file.
the liberty was given.
We file it for as soon as possible. Now,
Well,
move the matter.
24th is the date fixed before the court below.
Well,
for
that will-
yeah.
I'll indicate that I'm suffering. Millard will kindly come to the plaint once. Millard, this is a plaint for specific performance, nomenclatured as the prayers are nomenclatured as for declaration. Millard, the case of the plaintiff is that the plaintiff had entered into an agreement that I will obtain a tender of excavating sand from the banks of Damodar, and whatever sand will be excavated, I'll be selling it off to the plaintiff. That is the case they are relying on. And my lord, if my lord will kindly come to the agreement, that my lord will find at page কত নম্বর পেজ এটা বলো 100.
You are the defendant in the suit.
My lord, I am defendant number 1.
Page 100 is the agreement.
Page 100 is the agreement.
What is their capacity? What are they?
My lord, Ashit Boron De.
Yes.
My lord, here at page 100, my lord will see Ashit Boron De
Huh.
is the plaintiff herein.
So, what is his capacity vis-a-vis the land?
Nothing.
He's the owner of the land.
No, nothing, my lord.
Why did you enter into an agreement with him?
Well, he
What?
he just had entered an agreement with me that after I obtain the tender, I will be
He
selling.
will obtain the tender.
I will obtain the tender. I have obtained the tender.
Acha, very well.
I am performing the work. And after excavating the sand, I will be selling it off to him.
Right.
Now, my lord, if my lord will kindly come to page 100, Ashit Boron De, and my lord, there is a defendant number 2 in the plaintiff is one Arif Molla, who is the partner of this Ashit Boron De. But Arif Molla is added as defendant number 2. It's an unregistered partnership.
No, the first party is you.
First party is me.
Yes, in the agreement.
In the agreement.
Yes.
Ashit Boron De is the second party who is the plaintiff. And my lord, as the second party, Ashit Boron De and Arif Molla is the second party. My
Right.
lord will kindly come. My lord, here, Ashit Boron
Oh,
De.
Arif Molla is also the second party.
Yes, my lord. Here.
Let us see.
Arif Molla.
Ashit Barun De. Yes, both.
And my lord, kindly see how he has.
They are partners.
They are partners. My lord.
Very well.
So, my lord, Ashit Boron De has filed a suit of specific performance It's an unregistered partnership. It is clearly hit by section 69(2) of Partnership Act. My lord, the impugned order heavily relies on this particular agreement, but has given this a complete go by.
There is an ex parte ad interim order.
Ex parte. My lord, what happened? Bolchi. My lord, I'll indicate what happened. They initially added the government as the parties.
Right.
Their interim order was refused because they sought for ad interim. Their interim order was refused because of the leave under 80. That was not obtained. My lord, they challenged that order, that refusal order, before my lord's bench. My lord, onto that limited extent, allowed them to delete the government as parties and relegate the matter back to the suit court upon hearing both the parties. My lord's order, my lord will find that.
I have the copy of this order.
My lord, 190.
No, it's annexed.
It's annexed. My lord, 190, 189 is my lord's order. The operative part.
Okay.
189,
Volume 2 টা।
বইগুলো মাইন্সের
Oh, this is volume 2. 190.
Yes. So they deleted and
they deleted the
renewed the
government.
prayer.
Then my lord directed both the parties to be heard. They surreptitiously moved, my lord, because of the paucity of the business with the judges, my lord, because of the SIR, my lord, matter was transferred to some other. They overnight mentioned, got it heard.
Beyond the 7 days.
Within beyond 7 days, ঠিক আছে, সেটা অন্য কথা. And my lord, there was and the ex parte impugned order was passed. My lord, there was a clear direction. My lord, I placed it before my lord that there's a maintainability issue. So that's why my lord, upon hearing that, my lord directed that both the parties to be heard.
On
My
the
lord,
face of it, it was not maintainable. If you
Yes.
go by the plain, the suit is not maintainable.
The suit is not maintainable. Not on one score, my lord.
No, that was on section 80 ground. That objection taken by you was on section 80 ground, non-compliance of section 80.
I did not take any objection.
Before us.
It was before my lords that at that point of time also I indicated that the suit is barred.
Barred by section 80.
Not just 80, also 69 too.
Did you take that is not
My
recorded?
lord, that is not recorded, my lord. That is not recorded. So my lord directed, my lord said, let it be heard.
But
before
that direction is there.
That
Upon
direction
hearing
to,
both sides.
For a limited period, the matter is to appear on 23/4.
Yes, my lord. The matter is to be appeared, but for every
So
day
on
I'm
the face of the plaint, is it the suit barred?
Yes.
Is the court powerless to grant that
yes,
interim order?
my lord, it is settled law that what cannot be passed in the suit, in aid to that, no interim order can be passed.
No. Interim order should always be in the aid of the final release.
Yes.
So is the suit barred?
Yes, my lord. 69
From the plaint itself?
From the plaint itself. I'll indicate, my lord, in the plaint, to cover up this lacuna in the agreement, they define Arif Mullah in the plaint as an agent.
Yes,
Now, my lord, as far as the law of agency is also concerned in contract, under section 202, if he is an agent with stake that he has invested, or if there is an investment, the suit cannot be filed.
So you see, that can't be decided at the ad interim stage. For that, there has to be a contest.
My lord, in that case, then the plaint, my lord,
Where is that averment in the plaint?
My lord, the plaint he has averred
Yes, 72.
at 72. He
They
has
have said
averred.
that defendant number 2 is an authorized agent.
Well, that is what it has been defined in the plain. Well, of course, because they have completely suppressed. Well, that is inconsistent.
That
to what?
suppression is a different issue, you see.
I understand. Well,
See, you go by the plaint.
If we go by the plain, but the plain cannot be read in isolation from the agreement which it relies upon.
Very well. Read the plaint and the agreement.
Yes, my lord. Well, the plaint is at
72.
No, but even if you see the agreement, page
Yes.
100.
Yes.
Ashit Baran, they call the party and his partner stroke unauthorized, authorized representative.
Yes, my lord.
So it's arguable at least
Well,
whether
that is
this is a partnership firm in the true sense, because
well, unregistered partner. Unregistered
So
partner.
whatever it is, that is
partner maybe partner is a loose term. Now they don't say that there is a partnership as such, partnership firm. They say Ashit Barande and his partner stroke authorized representative. So both capacities have been
But partner is there, my lord. Matlab that is exactly why he has not, matlab in the plaint he has tried to cure the defect in the agreement. The defect that is in the agreement.
It's Noah stated in the agreement also that there is a partnership firm between them or a partnership between them as such.
Matlab will kindly read, matlab.
Yes, please come to the agreement.
Ashit Baron bearing Aadhaar such and such.
Description.
Having its registered address such and such. Called the purchaser and his partner. Representative.
Alternatively authorized representative. Both capacities.
Partner and authorized representative.
Not
But
and
The
or.
question is partnership's name is also not given. This is the name of the partnership firm
That
and
is
all
not.
this.
Perhaps not. Matlab,
Does not
it's
clearly
not
disclose the
essential.
bar on the face of the materials which were there.
Matlab, even if he is an agent, matlab, I'll rely on section 202 of the Contract Act. Even if
102 does not benefit you. It may benefit him. He may claim some right against his principal.
matlab, that he can. Matlab,
102 does not aid you. Come to your aid.
matlab, termination of agency where agent and interest is subject matter, where the agent is himself is an interest in the proper. Matlab, Contract Act.
You read out. You convince yourself first. Then convince us that this aids you.
Page section
202.
Section 202. Where the agent is himself an interest in the group
This
property.
pertains to termination of a agency. Where an agent himself has interest in the property, it cannot be terminated. That's between him and his principal.
Correct, Matlab.
You are not bothered.
Matlab, matlab, he has been nomenclatured here as an agent. Means his allegation is that his agent is carrying out the business with me.
He does not say it has been terminated.
He is saying that the agent is carrying out. I have circumvented him and I'm carrying out the business with his agent.
Section 69, palpably there is no bar from the plain reading of the plain. The other aspect is that you have not been given notice.
Matlab, that is there. Matlab, that is there. Matlab, I'll come to that. As far as the merit is concerned, I'll
I
argue
don't
on
find
merits as
any
well.
expressly bar from the plaint or the agreement.
Matlab, I'll argue on merits as well. This is the maintainable.
No, you argue the merits before the trial court. You see, it is an ad interim order. You get it contest, get it hard on contest.
My lord,
All these points will be kept open.
I will, my lord, buy. But my lord will kindly then in that case, I'll read the interim order and
here it says that the plaintiff filed laminate copy such and such, send the same through registered post as per track consignment report. You defendant number 1 received the same. Second, last paragraph of first page of the impugned order. So, that ground is also not correct that it was without hearing and all.
my lord, here, my lord, 192, my lord, will see that this order has been passed ex parte and it has been said that they have made endeavors to reach out to me and I
No,
was
no,
not.
served on you. You have received. That is the finding. That is the finding.
That's what they are saying.
No, not they are saying. The court has recorded from. Please come to page, the last paragraph of the first page of the impugned order. The very last paragraph of the first page of the
My lord,
impugned order.
on 27 to the plaintiff file as well. My lord, I've read this. My lord.
Yes.
Track consignment.
So that's the finding.
My lord, that is the, and my lord will now kindly come to the
You file
finding.
your objection and contest the injunction application. No difficulty.
My lord, what is happening? My lord will now consider balance of convenience and irreparable. My lord, I'll indicate, my lord, the amount of money I'm spending every day. My lord,
for what? Excavation. What have you been restrained from doing?
From
my lord, here,
excavating and selling.
the defendant number 1 restrained from
Selling sand
selling the sand
to
to
be
be excavated
excavated.
from the ghat to any other.
Excavation or কোনো বার দেয়?
That's one.
শুধু selling.
Selling.
You have been only restrained from selling. Sand is not such a perishable commodity that it will perish. If
No,
you...
it is not. It is not, my lord. It is not. But my lord, what is happening is, my lord,
you have not been restrained from excavating. From
No, my lord.
selling the sand to be excavated.
Well, in that case, my lord will clarify because what they are doing is they are trying to represent this work and my entire work has been stalled because of this. Well, they are using the police force.
We'll take your argument and say that this does not amount to a restraint order on your excavation.
Excavation 1 and my lord, this is the money I'm spending daily, like on weekly basis.
So
on
you can
this.
no, we won't look into these documents. You cannot at this stage because obviously because you are against an expert identity. We are not admitting the appeal, but we are saying that all questions are kept open. You will file your written objection within a limited period.
My lord, just to that extent that I can excavate, my lord. My lord, that may be clarified.
That
in
you
that.
see, the order is clear.
We'll record his
indulgence?
argument and say that the order is clear.
My lord, may I bring one
Yes.
indulgence, my lord? My lord, his stance is not correct. My lord, this document shows even after passing of injunction, he's selling out the sands.
We won't look into that document.
My
Since
lord,
we prevented him, we will not allow you also to file any further.
and my lord, he filed an bracketing application.
Well, I filed order
He filed order
711.
711.
I did.
After passing of this injunction ex parte, on the very next day, they come up with an put up application. Court fixed a date on 23/4/2026.
Yes.
For that.
Where is the problem?
let the-
Where is the problem? How am I
Lord,
barred to do
I'm-
that?
The present appeal has been preferred by the first defendant in a suit, couched as a declaratory suit, but also seeking mandatory injunction on the defendants to act in terms of an agreement entered into the parties, whereby the defendant number one stroke appellant apparently agreed to sell the sand excavated by the appellant from the location in question to the plaintiff stroke respondent number one. To sub next para, learned counsel appearing for the appellant argues that it will be evident from the agreement, captioned as a double inverted with a sale deed, double inverted clause, dated January 31, 2023, on which the plaintiff stroke respondent number one relies, that the defendant number two is a partner of the plaintiff, and as such, the said partnership firm being unregistered, the suit is barred under section 69 of the Indian Partnership Act 1932. For sub next para, it is further contended that by dint of the provisions of section 202 of the Indian Contract Act, an agency cannot be terminated if an interest of the agent has been created in the subject property. For sub next para, it is further argued that the appellant is losing huge amounts of money day to day, since the excavation work in respect of the sand is being stalled, taking undue advantage of the impugned order. So next para, insofar as the last issue raised by the appellant is concerned, we find from a bare perusal of the ordering portion of the impugned ex parte identity order that the defendant stroke opposite party number one has been restrained merely from selling the sand within double inverted to be excavated from the ghat number G capital ghat number 0121 caps DM 023 to any other person than the plaintiff as per the agreement in question. Which of next para, thus, there is no restraint order regarding excavation per se, but only regarding selling the land which is to be excavated by the defendant number one stroke appellant. Which of thus, it cannot be said that the appellant is adversely affected for stoppage of excavation, at least in terms of the order in question. Which of next para, secondly, it is not ex facie clear from the plaint and stroke or the agreement for sale on which the plaint relies that there is a partnership firm, which is required to be registered in law, comprised of the plaintiff and the defendant number two. Full stop. Next para, although such question is arguable, since in the descriptive portion of the agreement, defendant number two, Arif Mullah, has been described as a partner stroke authorized representative, PAR, এগুলো capital হবে আর double inverted মধ্যে partner থেকে represent. Partner stroke authorized representative, as to whether there is a partnership firm or not, the alternative argument also available from such description is that the defendant number two is merely an agent of the plaintiff, in which capacity the plaint also proceeds. It is well settled that at the stage of consideration of ad interim prayers of injunction ex parte, the court is only to go by the pleadings in the plaint and the temporary injunction application and the documents annexed thereto and or relied thereon. Going by such yardstick, we do not find that the suit is ex facie barred, comma, also, although it is open to the defendant stroke appellant to advance such arguments at further stages of the suit and the injunction application. Full stop. Next para, insofar as section 202 of the Contract Act is concerned, comma, the same pertains to termination of agency and is only material in between the principal and the agent, within bracket, the plaintiff and the defendant number 2 in the present case, bracket closed. Full stop. Thus, comma, the said provision does not come to the aid of the appellant insofar as the present appeal is concerned, comma, in any manner whatsoever. Full stop. Next para. The third ground which has been raised before us is that at a previous stage, comma, when injunction was refused to the plaintiff on the ground of bar under section 80 of the Code of Civil Procedure, comma, a coordinate bench of this court had observed that in the event the name of the state authorities stroke instrumentalities are deleted from the plaint, comma, as no effective relief had been sought against them, comma, the plaintiff would be at liberty to renew its prayer for his prayer for injunction. Full stop. Next para. In the same order, comma, it was also recorded that if so made, comma, the learned trial judge shall consider the grant of ad interim prayers upon hearing both parties. Full stop. Next para. However, comma, from the recording in the impugned order itself by the learned trial judge, comma, we find that the plaintiff stroke petitioner sent a copy of the fresh injunction application through registered post on the defendant number 1 stroke appellant on March 11, 2026, and as per postal track consignment report, comma, the defendant number 1 stroke appellant received the same on the same date. Full stop. Next para. Thus, comma, it cannot be argued that the defendant number 1 stroke appellant was not given any opportunity of hearing as such. Full stop. Next para. Thus, comma, the present appeal cannot be sustained on any of the grounds taken by the appellant. Full stop. Accordingly, FMAT 112 of 2026 is dismissed under Order 41, Rule 14 of the Code of Civil Procedure. Full stop. Can 1 of 2026 is also disposed of consequentially. Full stop. It is made clear that the above findings are tentative and it will be open to both parties to canvass all issues required to be urged by them independently without being influenced by any of the observations made herein above. Full stop. If the defendant number 1 stroke appellant files its written objection to the temporary injunction application filed in the trial court within a fortnight from date, comma, the learned trial judge shall make endeavor to dispose of the injunction application as expeditiously as the business of the court permits.
And well, an excavation, right? Well,
They have
put it in our order.
They have filed one vacating application already.
Filed vacating application.
They have filed
The above directions shall not be a bar to the learned trial judge first adjudicating the applications pending at present at the behest of either party.
I'm grateful, grateful. Grateful.
7-11 টা যদি আগে শুনে না বা
86, my lord, I appear for the petitioner.
Yes.
My lord, here in this matter, my lord, the plaintiff.
ভ্যালুয়েশন অফ বিলেট 7,300 টাকা ভ্যালুয়েশন বলছি, তাহলে তো এই কত 60,100 60,100 with the appeal live before this court 60,100 no appeal time maintainable we find at the outset that the appeal is not maintainable before this court due to comma since it is the concerned district court which has the pecuniary jurisdiction to act as the appellate forum. Full stop. Next para. Accordingly, the condonation application is redundant. Full stop. Hence, comma, can 2 of 2026 is disposed of by holding that the appeal itself is not maintainable. Full stop. Consequentially, the appeal as well as can 1 of 2026 are also disposed of with liberty to the appellant to prefer an appeal against the impugned order before the appropriate court having jurisdiction. Full stop. The learned advocate on record for the appellants is granted liberty to take back the certified copy of the impugned order from the department upon furnishing a photocopy of the same for the records. ভুলে আসছি স্টিচ করা ছিল হ্যাঁ ক্যান ওয়ান বলে দিয়েছি ওখানে বলে দিলাম যে ক্যান ওয়ানটাও বললাম যে বলে দিলাম তো এক্ষুনি তিনও আছে
No, all interlocutory applications.
What is can 3?
It is a leave to appeal.
As well as can 3.
নাম্বারটা মেনশন করে
All interlocutory.
Lord, 87, my lord. I'm praying for not today, my lord.
Why?
My lord, it's a hearing date and I've missed the brief. Mr. Chittapriya Ghosh is appearing.
On the prayer of the appellant, the matter is adjourned for the day.
Grateful.
Only your name.
Yes, my lord.
None appears for the parties at the time of call, adjourned for the day. Same.
No time for the appeal. My lord, in a suit for partition, I am for the plaintiff.
পরে ফাইলগুলো একটু বার করে রাখতে বলুন দেখুন করতে suit for partition you are the plaintiff what are you telling
I filed an injunction application. My lord, thereby injunction application was allowed on the contest that both parties will maintain the status quo. My lord, on the next occasion, my lord,
ad interim injunction was allowed not injunction
ad interim
application.
injunction. My lord, on the next date, my lord, the defendant filed an application under Order 39 Rule 4. My lord, in the said application, my lord, learned trial court allowed them to permit the raised construction.
No reason নেই দেখুন
Order was modified.
না 39(4)(a)
39(4)
কেটে করে দিল
ও 18/2/2000
হ্যাঁ
কনসিডারিং থেকে করে দেখুন একবার
My lord, land is recorded as
রিপোর্টটা দেখেছি বলছে ওভারঅল কন্ডাক্ট কনসিডারিং allowed
yes, my lord, specifically allowed the construction.
Subject to strict directions to be followed by them.
My specific contention is that land is recorded pond. My lord,
রিপিট করে দিল
এটা মানে মডিফাই করে দিয়েছে
মডিফাই করেছে না মডিফাই মানে প্রথমে তো স্ট্যাটাস করে দিয়েছিল where is the first order
my lord, first order, my lord, my first order at page my lord, 33 of my can 1.
Yes, when was this order passed? Earlier? Ad interim order of status quo was passed when?
My lord, on December 3, 2025. That is page 33. 33 of can 1.
Both plaintiff and defendant in general and defendant number 1 in particular are directed to maintain status quo in respect of nature, character, possession and transfer. Nature, character, status quo দিল তারপরে
ক্যারেক্টার মানে কি এই যেখানে
কনস্ট্রাকশন করতে দিল স্যার
পজিশনটাকে এক্সটেন্ড করতে দিল
পার্টিশন
they are in possession of that in the one storied building.
This is my content.
সব নিচেই তো সব
ফিজিক্যাল পজিশন আছে
তো যদি বেটার পার্টি কনস্ট্রাক্ট করে না তাহলে
এটা মুখোপাধ্যায়ের হলো স্ট্যাটাস কো থাকবে এবার
মুখোপাধ্যায় নিয়ে জানা সত্ত্বেও যে শুটের নোটিশ পেলো ইনজাংশন নেই তাও কনস্ট্রাক্ট করলো ইসরায়েল ভার্সেস শামশের আশুতোষ মুখার্জি বিচ কফটির সঙ্গে বসে বলুন যে ভাঙো ইনজাংশন ছিল না তাও নোটিশ পেয়ে তুমি করেছো
দিকে সে ইয়ে করেছে ওই একটু মডিফাই করে করেছে
কিন্তু রিজন তো থাকতে হবে কোন রিজন নেই এটা স্টে করে নোটিশ সার্ভ করতে হবে The present appeal has been preferred against an order whereby an ad interim order of status quo has been vacated under Order 39 Rule 4 of the Code of Civil Procedure. Full stop. It prima facie appears from a perusal of the impugned order that the same is devoid of any reason vis-a-vis the parameters stipulated in Order 39 Rule 4 of the Code. Full stop. Next para. Accordingly, the appeal is admitted and shall be heard on the above question and the other grounds taken in the memorandum of appeal. Full stop. There shall be stay of operation of the impugned order till disposal of the application. Full stop. The respondents shall file affidavit in opposition to Can 1 of 2026 within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall next be listed in the monthly list of June 2026, when an affidavit of service shall be filed by the appellants upon service of copies of the application bearing Can 1 of 2026 as well as
Can 2 for injunction laws.
Can 2 of 2026 along with a copy of the memorandum of appeal on the respondents.
But injunction.
No further injunction. Stay. There is already an injunction. We stay the operation means the status quo is there. Yes. What is the meaning of stay of the
Then, my lord,
status quo operates?
Then Can 2 should be in favor. That is injunction.
But you serve, you have spent some money on printing, giving dictation, stenographer charges. For that you have directed service of copy.
Yes.
Next. দেখুন সব হয়ে গেছে। Can 1 2 3 সার্ভ করতে হবে। Want a stay, 2টা injunction। বুঝে নিয়েছি আমি, করে নিয়েছি। দুটো সবকটা সার্ভ করতে বলেছি। 1 2 আর মেমো।
91 lordship. I'm for
defective.
I'm for the app. No defect, lordship.
No defect.
Cured. There was a
yes defect, but now no defect.
Cured.
What is the matter?
Matter is, lordship, I'm for the appellant / plaintiff. The appellant had filed a suit for cancellation of deed, declaration and permanent injunction. The matter is that your lordship, that in May 2025 the respondent came to our property and tried to take the possession, showing a deed which has they projected that has been executed by our mother, means appellant's mother, but my mother has passed away in the year 2016 and the deed is shown is of year 2024.
Did you produce any photo certificate, any death certificate?
I have produced, and instantly I lodged a police case and charge
suit and injunction.
Sheet has been submitted. Where
on a different footing, criminal cases on a different yardstick.
Yes, your lordship.
But injunction has been refused.
Observing that it is a good case for trial, but
what sort of injunction did you want?
I thought not to
third party.
Create third party.
Show us the death certificate.
Death certificate.
And the deed.
Third death certificate is on page 30, your lordship.
We hope you annex that with the temporary injunction in the trial court also.
Yes, your lordship. Page 30 is death certificate, lordship.
Shakina baby, yes, and deed.
And deed is
yes,
35 onward.
Diabetes case রয়েছে মারা গেছে আগে তারপর ডিট করে ক্যান্সেলেশন অফ চেক করে যে ভেন্ডার সে মারা গেছে 16 সালে এটা এক্সিকিউট হয়েছে 24 এই হচ্ছে ইয়ার্স অফ ভেন্ডার অ্যালেজ ভেন্ডার যে মহিলা ছিলেন তিনি মারা গেছেন ডেথ সার্টিফিকেট দিয়েছে 2016। আচ্ছা এবারে এই ডিটটা দেখুন যেটা করছে যেটা ক্যান্সেলেশন চেয়েছে সেটার ডেট হচ্ছে 2024 কাজী 8 বছর বাদে মারা যায় যেটা ফ্রডুলেন্ট কেস বলছে যে ট্রান্সফার করে দেয় আমার সুট 10%
ও মানে ওই যে নতুন ট্রান্সফার
কেন দিল না দেখিনি এটা
arguable case. Made out an arguable case, but made out at the time of trial.
No urgency বলে হ্যাঁ
arguable case.
তাহলে তো কোনো ম্যাটারই ইনজাংশন হবে না at the time of trial তো সবই হবে।
Okay, defendants have casted a cloud.
হ্যাঁ তবে
for no urgency.
কি প্লেন্ট প্লিডিং দেখে যেতে হবে। What is the urgency of pleaded?
Urgency is that they may create a third party interest, Lordship.
May
And
create or are trying to create.
they may create it. It cannot be said. And
May create is not urgency.
but I may the civil rights can be compromised, Lordship, because they have forged the deed, and which can be seen from page 55, Lordship. I have an extra charge sheet, copy of the charge sheet.
Charge sheet is on the fraudulent.
Fraudulent, that my death certificate of my mother has been verified, and it transferred from page
So not
50.
only a prima facie case, that's you are confusing prima facie case with urgency. Prima facie case, we find that you have got a prima facie case, but you have to plead that they're trying to do something. Yes, yes. We have pleaded in paragraph 9 of your injunction when the defendants along with they came with to take forcible possession. The appeal arises out of the refusal of ad interim injunction on the prayer of the plaintiff stroke appellants, comma, who are the heirs and legal representatives of one
Shakina Bibi.
please don't interrupt. One Shakina Bibi, Chhakina Bibi. Which of next para, the case of the plaintiffs is that the said Shakina Bibi met her demise on December 25, 2016, whereas the deed, comma, of which cancellation has been sought in the suit, comma, is of the year 2024, that is much subsequent to such demise, and is thus fraudulent. Full stop. It is also contended that the plaintiffs lodged a criminal complaint against the defendants on the ground of such such fraud and forgery committed by manufacturing such deed. Full stop. Next para. The learned trial judge, comma, while refusing the ad interim injunction, held that a cloud has been cast on the title of the appellants, but nonetheless went on to refuse ad interim injunction on the ground that there was no urgency. Full stop. Next para. At the stage of consideration of ad interim prayers of injunction, comma, it is the plaint and temporary injunction application and the documents relied on therein which are to be taken for the purpose of ascertaining whether a prima facie triable issue has been raised. So we find from the averments made in the plaint and the injunction application, comma, particularly in paragraph number 9 thereof, comma, that the plaintiff specifically allege that the defendants are trying to take forcible illegal possession of the suit property on the basis of the fraudulent deed, comma, thereby creating sufficient and reasonable apprehension that the respondents might attempt to transfer the property in favor of third parties and or disturb the peaceful possession and enjoyment of the plaintiff with regard to the same. Full stop. Accordingly, there are sufficient prima facie case as well as urgency having been made out by the plaintiff stroke appellants, comma, on the face of it, comma, prima facie, comma, the learned trial judge erred in law in refusing to grant ad interim injunction. Full stop. Accordingly, FMAT 67 of 2026 is admitted and shall be heard on the above questions as well as the other grounds formulated in the memorandum of appeal. Full stop. The appellants shall serve copies of Can 1 of 2026 as well as the memorandum of the appeal on the only 1 and 2.
On 1 and 2.
On the defendant stroke respondent numbers 1 and 2, indicating that the application shall next be listed for hearing in the monthly list of May 2026. Full stop. The appellant shall file an affidavit of service on the returnable date. Stop. Service of notice on the pro forma defendant stroke respondent is dispensed with since no relief has been sought against the said pro forma respondent. So the next para, the respondent numbers 1 and 2 and or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and or encumbering the suit property in favor of any third party in any manner whatsoever, and stroke or from disturbing the peaceful possession of the plaintiff stroke appellants, as well as from changing the nature and character of the suit property till disposal of the application.
So,
yes. এগুলো সব
এটা থাকলে আমরা ডিসপ্লে
থাকে বা রেসপন্ডেন্ট যদি থাকে না হলে
My lord, Mr. Oturu Banerjee is appearing.
মিস্টার অতুল ব্যানার্জি what happened to him?
My lord, due to some personal difficulties, he is unable to come court. My lord, I am
Not come to court.
No, my lord.
On the
I
prayer of the
only
appellants,
not today,
the
my lord.
matter is urgent for the day. Your name only. Yes.
So
Can't hear you. Microphone.
adjourn today, my lord.
Adjournment.
Huh.
Refused. Move the matter.
Bordon is not here, my lord.
Who is not here?
Mr. Bordon engaged in another court.
You are there. You move the matter. You are sufficiently senior. Move the matter.
Not.
Very well.
Matter, Lord, I could not read the brief, Lord. I asked him that.
On the prayer of the appellant, the matter is adjourned for the day. Yes. Only your name, not Mr. Bordon's name or anybody, any senior counsel's name. Yes.
Before moving the matter, my lord, could I start with 2 points which are against us and our conduct
If
which
is on the other side, then yes.
our conduct which needs admonition also, my lord.
They've done.
Kindly,
Lord, only
yes.
one thing, Lord, before my learned friend will place this. Lord, we have also filed, Lord, an appeal against the same order. Lord, this, Lord, is not appearing in my Lord's list. If
Same order,
this off,
same order, there's a challenge.
my Lord,
We'll
he
do that
says,
together.
Your lordship can hear it from the same thing, my lord. It's the same order they have challenged also.
The appeal is not in the list, Mr. Gupta. Is it appeal in the list? Wait for 2 further weeks. See, you are already at fault in something.
No, that is not on the merits, but otherwise I need to, my lord, indicate to your lordship.
So we will not admonish
One is condemnable, other is fault.
That's a trade-off.
Yes.
We'll take their appeal along with you and don't admonish you now. Learned senior counsel.
Only your lordship is, my lord, keeping it tomorrow or, my lord, Monday, any day, my lord.
We'll keep it
Because
on
there is-
Monday. I will not be there because of the circuit, but it will be in the list. If you have extreme urgency, you can give with notice to them. You can mention before. You can take a or if there is a better order, take a chance.
Only thing, the meeting of a trust has been stayed. That is the only thing. Because everything, the trust has to go.
Then virtually it will be a hearing of the appeals. We cannot pass any ad interim order. Meeting has been
Your
stayed.
lordship's not-
If you open that up at this stage, we cannot. So in any event, it is better for you also so that their appeal is also heard. Learned senior counsel appeal. Which respondent are you representing, Mr. Chaturvedi? Plaintiff's respondents will
Possibly
do.
all the
Lord,
respondents.
I am, Lord, the defendant respondent.
Oh, sorry. Different.
Respondents 1 to 5.
5 must be. Please check up. 1 to 5.
Yes, ma'am.
1 to 5.
Well, could I indicate from the memorandum of
Yes, yes,
appeal
you can
filed by
also.
him? Filed by my learned senior friend's client? My lord?
No.
No, that has been filed
You have got a copy of that also?
by all the respondents. Yes, yes.
Where?
That has been filed by all of them.
Including 6?
No, 6 is not. Only the respondents 1 to 5.
It is submitted by learned senior counsel appearing for the respondent numbers 1 to 5.
1 to 4, my Lord, kindly include because Vakalatnam is for 1 to 4.
Very well. 1 to 4 that an appeal has been preferred by the said respondents as well against the self-same order which is impugned in the present appeal. Full stop accordingly, comma, for the sake of propriety, let the said appeal, what is the number, please?
Lord, FMA 434.
Oh, FMA 434 of
2026.
2026, along with the connected application, comma, if any, be listed with the present appeal on
except Monday, my Lord.
What remains? Monday, because you don't have connectivity, you won't have connectivity on Monday, and because there will be less judges on Monday, that's why you are abstaining.
My learned junior, my Lord,
Today you have sufficient judges and connectivity, but
no, I would lack assistance of my juniors on that day. That is my difficulty. I am
Tomorrow your lordship sits singly most of the...
yes, throughout the day. On April 13, April 20, 2026, under the same heading. Wait for a week, Mr. Gupta, you have waited for
Yes.
some.
Nowadays difficulties with the daughter's school.
Why?
13, 14 both the school. Only 15th is a holiday.
Yes. Yes. True. Absolutely correct. 95, who is appearing? Yes.
My lord, I am appearing for the appellant, my lord.
Yes.
Suit for partition, declaration, and permanent injunction along
One
with an
second. There is no caveat checking? Oh, because it's an application for appropriate order. What do you mean by that?
my lord, for injunction, actually, I have paid for my
But
lord.
the office ये आजकल endorsement है ना application है caveat endorsement नहीं कर
আমি ভাবি কি করে caveat থেকে আমি
আটকে দিতে হবে we'll take up we'll direct the office to give a caveat note
My lord.
Did you receive any notice of caveat?
No, no, my lord, never.
What is the appropriate order application?
My lord, that is for injunction, my lord, because expert order of injunction was, my lord.
Surprisingly, we find that there has been no caveat checking by the department at the time of filing of the application. Full stop. We deprecate such practice and request the concerned filing section to ensure that no application in connection with an appeal can get through to the bench before caveat checking. Full stop. The matter be sent immediately to the appropriate section for endorsing a caveat note and be listed next on April 13, 2026 under the same heading.
My lord, great.
ডিপার্টমেন্টে আজকেই পাঠিয়ে দেবেন বলবেন যে আমরা খুব সিরিয়াসলি কোর্ট এর পরের বার কোর্টে ডেকে পাঠাবো ওটা সেকেন্ড আইটেম দেখলাম একটু বলে দেবেন এটা এই থার্ড টাইম দেখলে কিন্তু কোর্টে ডেকে পাঠাবে বলেছে
গ্রেটফুল
যে কোনো অ্যাপ্লিকেশন থাকলেই ক্যাভিয়েট চেকটা করে দেবে সেকশন 5 করে না কিন্তু তাও করে দিতে হবে অ্যাপ্রোপ্রিয়েট অর্ডার বলে যে কোনো অ্যাপ্লিকেশন ইনজাংশন অ্যাপ্লিকেশন চেক করে পাসওয়ার্ড আপনার সব হয়ে গেল অর্ডার পাঠানোর লিস্ট পাসওয়ার্ড Yes,
My lord, I appear for the respondent. My lord will kindly permit me to appear online today.
Yes, Mr.
But I filed a suit for a declaration that, my lord, a particular agreement that I entered in 2010 that is valid, and my lord, I am entitled to work on the basis of that, my lord, particular, my lord, the development agreement.
You are the developer.
I am the developer. It was an unregistered, unstamped, because at that point of time, it was not required, my lord, for her to be registered. I think from 2012, my lord, onwards, there was an obligation to register. The only thing, my lord, for which, my lord, my injunction was, my lord, refused on contest was, my lord, that according to the learned judge, my lord, there was my lord, a suppression of my client in the application, wherein I could not, my lord, say that, my lord, the plan that was sanctioned was, my lord, sanctioned on the basis of a misrepresentation on behalf of, my lord, the tenants who are occupying the building.
This is
Secondly,
against order 39 rule 4 order.
No, this is not an injunction refused
Finally.
on contest. On contest.
So
I am the plaintiff. I did not get an order of injunction.
So first ground is that you suppress that there are tenants while
That is
getting
the
the
reason.
sanction plan.
Yes, that is the reason why the learned judge said my application is liable to be rejected. And the other one was, my lord, that since this was not a suit for, my lord, the specific performance of contract, and accordingly, my lord, the learned judge was of the opinion that my suit is not maintainable because I only prayed for a declaration, and my lord, the suit cannot be maintained. So, my lord, this is the sum and substance of, my lord, what, my lord, the order is. Now, kindly, my lord, have a look into, my lord, my prayers, what I made, my lord, at page 13 of the part 1 of, my lord, the stay application. But there is also a prayer, Lord, that there was a subsequent registered, Lord, a development agreement of 2022. Lord, at page 13, A15, paragraph A15. So, Lord, the first one was, Lord, I mean the second B, a degree for declaration that the agreement and a memorandum of understanding executed on 24/10/2010 is valid, binding upon the defendant number 1 and the plaintiff.
No, this is not the complete. Oh, acha, yes.
Well,
A, B
this
is
is,
there.
Lord, yes.
Right. Degree for
আপনারা
yes,
প্লেনটা থাকলে প্লেনটা বার করে রাখুন।
24.
C is a declaration for permanent injunction restraining the defendant number 1 such and such to not to cancel, rescind or set aside the agreement executed on
agreement,
such
yes.
and such.
Right.
And D is a decree for permanent injunction restraining the defendant, servants and agents not to give and further effect to the registered development agreement registered on 2022 and not to give effect and further effect to the general power of attorney dated such and such.
But the prior agreement was registered. The second is
The
unregistered.
first one was 2010 was with me. It was not registered. The second one, I was Lord made one of the directors Lord in the company who was Lord the owner of the property. So Lord, the second agreement when it came, it was with a third person and it was registered and both Lord the development agreement as well as the power of attorney was registered. Hence, Lord, I was compelled to Lord seek a relief, Lord, this D, prayer D.
Please, I can. The first agreement was for what?
Development.
Second is also for development.
Development. First one is an unregistered development. Second one
What
was
is the difference between the two?
But
How are you affected?
because Lord, in the second registered agreement, Lord, the third party is not the developer.
Oh, that's with the third party, not with you.
Yes. That's the reason, Lord, I am asking for Lord not to give any further effect to the registered development agreement.
But you are seeking a declaration. The court is right that you are not seeking a specific preference of the.
But that is
you cannot
not
have an infinite declaration against them.
Twofold argument on that, Lord.
Yes.
First of all, Lord, that I have asked for Lord a deed to be declared, Lord, a permanent injunction on the status of a deed. That was also to be considered by the learned judge.
No, but Mr. Mukherjee, that's understand the effect of it, which you quite understand.
Lord, I do. I know, Lord.
You quite understand that I get a declaration that I have an agreement with you forever, permanent declaration and injunction, and you cannot do anything. And then I don't seek specific purpose.
I understand. We are handicapped with Lord the framing of the suit. Lord,
the merit of the matter.
Framing of the suit. Lord, I understand that. Lord, I am trying to take out Lord out of that what I have. Lord, to make out some case Lord about two things. Lord, that so far as Lord the D is concerned, there is Lord a prayer to that effect. Secondly, Lord.
So you say
the
that
2010 Lord agreement was never cancelled. So without the cancellation, this is the best point that I can forward before your lordship. I am entitled to seek a declaration, albeit without seeking a specific performance, that it is valid and binding.
You don't understand this subtle point.
Lord, this is a point which is Lord, I have to.
The subtlety goes above our head.
Yes. I have no other point, Lord, excepting Lord. I have not prayed for Lord specific performance. I know. I know, Lord, I have not prayed for specific performance, and that is one of the reasons, Lord, why the injunction has gone.
Specific performance, declaration, it is subsisting.
Judgment.
আমি চাইলাম ডিক্লারেশন যদি এফেক্টটা কি সুটটা ডিক্লারেশন থেকে যে এই ডিগ্রিটা আপনাদের মধ্যে আমাদের মধ্যে বাইন্ডিং রয়ে গেল মানে অন্য কারোর সঙ্গে ডেভেলপমেন্ট এগ্রিমেন্ট আমি এন্টার করতে পারবো অনন্তকাল অথচ আমি স্পেসিফিক পারফরমেন্স চাইলাম তাই নাকি এসেনশিয়াল 34 প্রভিজে তো আসছে ডিসিসটা কোথায় ডিসিস মানে কিছুই নেই
I absolutely bow down, Lord, what is falling from your lordship, Lord, but
what we can do at this stage?
Nothing, we can dismiss it. Can't do anything. We have done sufficiently. We have heard Mr. Mukherjee for so long.
Kindly do so, Lord. I will not be holding the court any longer.
Learned senior counsel, and the present appeal has been preferred against the dismissal of the application of the plaintiff stroke appellant for temporary injunction. Push up. The suit has been filed by the plaintiff stroke appellant for declaration, primarily for declaration that an agreement, a development agreement between the parties, comma, allegedly entered into on December 24, 2010 is valid and binding upon the defendant stroke respondent number 1 as well as from consequential permanent injunction. In the plaint, comma, the appellant also prayed for a decree for permanent injunction restraining the defendants and their agents from giving any effect or further effect to a subsequent registered development agreement which was dated September 27, 2022. Next para, the learned trial judge dismissed the temporary injunction application on the ground that although the plaintiff stroke appellant sought for a declaration of the validity of the unregistered and unstamped agreement dated December 24, 2010, the necessary consequential relief of specific performance was not sought. Full stop. Furthermore, the learned trial judge. What other ground, Mr. Mukherjee, sir?
Lord, that is suppression of fact. Your lordship will kindly come to Lord the ordering portion at page Lord the page 14 rather.
Furthermore, the learned trial judge held that the plaintiff stroke appellant was guilty of suppression of the fact that there are existing tenants of the subject property while obtaining a sanctioned plan for development on the subject of the suit property. Next para. Learned senior counsel submits that there was no material suppression at all on such count, as well as that the relief of specific performance need not have been prayed for in the present suit as framed, since a consequential relief of permanent injunction has been sought in respect of a subsequent agreement entered into the parties, which in effect seeks to negate the agreement of 2010. Next para. However, we are unable to appreciate such contention of the appellant, since the effect of the declaration as sought as the principal relief in the suit would be that there would be a valid and binding agreement, a development agreement between the parties of the year 2010 without the plaintiff being tied up with the liability to seek a specific performance of the same. Next para. Also, prima facie, the suit is hit by the proviso to section 34 of the Specific Relief Act 1963 bracket as amended till date. Bracket closed. Next para. Hence, even apart from other grounds, the injunction was rightly refused on such ground alone. Next para. Accordingly, we do not find any scope of interference with the impugned order. However, we make it abundantly clear that the observations arrived at by us as well as in the impugned order are tentative in nature and shall not sway the learned trial judge in adjudication of the suit, which shall be decided in accordance with law and independently of the observations indicated above. In the light of the above observations, FMA 1719 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequently, Can 1 of 2025 is also dismissed. No address to cause urgency.
I'm grateful.
Relieved. Yes, thank you. Give your name in the inbox, Ms.
Madam, my advocate on record is there.
Yes, she's there. Yes. Yes. Similar matter or different?
Different.
No, different.
No.
You're for the respondent.
If my lord recollects, I am led by Mr. Bhattacharya. If my lord recollects, last occasion, my lord's order was there that arising out of
Counterclaim, yes.
counterclaim.
Taken instruction.
Taken instruction.
Your suit for declaration of tenancy rights was dismissed, or that was your counterclaim? Oh, their suit for eviction of licensee.
Yes.
Your suit for specific declaration of tenancy.
No.
Your counterclaim for
My,
declaration of tenancy. Both theirs was allowed, yours was dismissed.
my lord.
So this appeal is against which one?
This appeal is against the main judgment, not
Main
the
judgment means
the count. Their decree.
of eviction.
My lord.
So then you are waiving your tenancy right.
No,
Yes.
I have.
Declaration suit has been dismissed.
My lord, I have.
So Bhattacharya is deliberately abstaining himself. File an appeal, file a section 5. Don't you know these things?
He instructed.
Take time from us. We are ready to grant time.
My lord, he instructed me
Section 5. One second.
to take.
Wait, okay, license. वो काउंटर क्लेम করে বললো যে নামে টেনেন্ট কাউন্টার ক্লেম যে আমি টেনেন্ট ওর ডিগ্রি সুটটা ডিগ্রি ফোর সুটটা ডিসমিস করলো বলে তুমি টেনেন্ট না ওর এভিকশন সুটটা ডিগ্রি করতে একটা অ্যাপিল করে একটা অ্যাপিল করেছে অ্যাপিল কোর্টও এখন একটা অ্যাপিল করেছে একটা অ্যাপিল যদি
May I?
আনচ্যালেঞ্জ থেকে যায় তাহলে তো হেরে যাচ্ছে কোর্ট যদি ডিক্লারেটরি বলছে যে এভিকশন ডিগ্রিটাকে চ্যালেঞ্জ করছে তাহলে ওয়েভ করছে যে লাইসেন্স একটা ডিক্লারেশন চেয়েছিল ফ্রম দ্য টেন এটা টার্ন ডাউন তার এগেইনস্ট অ্যাপিল নেই তাহলে ওটা নিয়ে হ্যাঁ
My last occasion, your lordship asked him.
we did not ask him. We asked her.
Asked her.
And she's answering. Please let her. You have come in between. Don't have to impress your client by showing that you are.
No client is here.
Yes.
2 appeals were filed. One against the counterclaim and
You
one.
have been filed.
Yes.
Where is the other one?
No. Before the appellate court.
First
not
appellate
before
court.
the first appellate court, not
The
before.
valuation
my
is
lord.
different. That's
My lord.
What happened to that appeal?
That was dismissed. I have to file a second appeal before my lord.
Do that. Ask for time.
And my lord.
Brush aside Mr. Mukherjee's objections.
May I take adjournment before the court below since
Why I'm
the
because this
execution
has been pointed out long ago. What they have done, common.
long ago, no, my lord, day before yesterday.
As of today, you are Ms. Ghosh.
My lord.
Ms. Ghosh, as of today, this appeal does not serve any purpose. We'll have to dismiss it in any event in view of the other decree remaining against you. You have been declared not to be a tenant. And if we proceed on that premise, as of today, you have to proceed on that premise because there is no appeal against that. If we proceed on that premise, in a suit for eviction of license, you have virtually no defense apart from tenancy or some other status. That having failed, a licensee filing of a suit is sufficient notice. And you don't have any defense to the license eviction suit also. As a matter of course, license eviction will be granted. So as of today, if you hear your appeal, we can only pass an interim order if you admit your appeal. If you hear your appeal, it will be dismissed without looking into the papers. On the basis of the dismissal of your counterclaim, then it's a matter of course, eviction decree. Do you get what you are saying? We cannot pass any interim order at this point of time. We'll have to dismiss the appeal if you hear it, if you insist. What is the otherwise? Is there any other substantial question of law?
Because my lord, substantial question of law is there because my lord, I was not a party in the previous suit. The respondents have filed.
Of course, you elect whether you want to move the. If you hear you, then you will have to decide it. It's not a warning.
No.
It's a warning, not a threat. It's a warning.
I will not place. I will not
Don't place. Don't take the risk. If we are not satisfied on, you have to have very strong substantial questions of law in this sort of suit.
My lord.
We are putting you on notice. So therefore, if you move, then we cannot then resile from that. We will have to decide it.
I will not place.
So make your prayer. We are granting it. We have not made the prayer.
So can it be adjourned for the week?
On the prayer of learned. So you will file a section.
I file a section 5 along with the appeal against the counterclaim.
We take note of the preliminary objection taken by the respondent on the last occasion when the matter was called on for hearing, comma, rightly in our opinion, comma, to the effect that only one second appeal has been preferred, although the first appellate court has turned down 2 appeals of the appellants, comma, one against the dismissal of their counterclaim seeking declaration of tenancy rights, and the other from a decree of eviction of licensee granted in favor of the respondent. Push up next para. The respondent is justified in pointing out that if either of the decrees remain, comma, the other appeal, the other challenge may be rendered a non-starter, non-starter. Push up next para. On instruction, learned counsel for the appellants apprises us today that the present appeal has been preferred against the decree of the first appellate court, whereby the eviction decree passed in the suit of the respondent was affirmed. Puts up next para. However, learned counsel for the appellants points out that the title appeal which was preferred against the dismissal of the counterclaim of the appellants has since been dismissed, against which the appellants intend to prefer a second appeal. Push up accordingly, the appellants seek an adjournment. Push up next para. Accordingly, comma, to enable the appellants to prefer the other appeal with a consequential with an accompanying application for condonation of delay in preferring the same, comma, the matter is adjourned for 2 weeks.
2 weeks.
For a fortnight from then now, and shall next be listed on be adjourned for a fortnight from now, adjourned till May 5, 2026. First up, in the event any other appeal is preferred in the meantime, comma, liberty is given to the appellants to mention the same for inclusion, for being tagged along with the present appeal, comma, upon prior service of a copy of the memorandum and the connected application of the said appeal on the learned advocate for the respondent in the present appeal.
Only one thing.
First, there one thing, yes, complete.
One prayer, my lord, the appeal may be filed without certified copy of the suit court, because already a certified copy is there with this appeal. Suit court, only for suit court.
But there, my lord, in the civil rules and order, if he apply before the court below, he can get back. Moreover, my lord, your lordship observe that after filing the appeal, if he mentioned, my lord, both the appeal be heard together. My lord, kindly see, the appeal court order was passed in October 2025. He has to cross the hurdle of allowing Section 5 application.
Definitely, but we'll permit that appeal to be filed without the certified copy of the trial.
That is, my lord, he can file. Only thing that he can file, my lord, with the photocopy. What we have the experience, the photocopy.
Both the appellants and she or she's.
She can file the appeal, my lord, with the photocopy of the certificate of the trial court. No leave is required subject to correction. What we learn from your lordship, my lord.
And you have learned from us it's wrong, and you have definitely not learned it from me.
No leave is
from
required.
Justice Chaudhary also, no.
No leave,
I don't believe
no leave is required.
No, I don't know of that law.
But with the appeal courts or
The
judgment,
prayer of the appellants, comma, leave is granted to file the other second appeal without the
It had prepared
certified copy
it had
of the
prepared.
judgment and decree of the trial court.
Grateful, my lord.
Next.
What we used to file with the appeal court's judgment, and if the trial
They have not filed it simultaneously, Mr. Mukherjee. It will not be accepted by the filing department.
now
Your precious, after people like you have influenced the filing section, maybe they are now accepting. Should not be accepted.
I'm grateful.
People like you means senior people who have some standing in the bar and are heavyweights
I'm
also.
sorry, my lord.
Then it's all right. Yes, Mr. Banerjee, another heavyweight.
That just by the
That's now an abuse.
so for me it's actually the weight. This is not
No. Your height is also. Yes. Yeah, you're for the respondent.
I'm for the respondent being led by
I will be.
Oh, that.
the
another
matter.
heavyweight.
Yes, Your Lordship.
Otherwise, the rest of the day. Justina.
Your Lordship is taking up today because other bench was hearing. That's why I just generally asked. That is the only reason.
You're right.
He is going to on law in personam and rem.
No, we are being very candid, Mr. Banerjee and Mr. Sinha and Mr. Dutt, everybody, that 4:10 we have to rise. We have to rise because I have a different bench. So it won't be concluded within that period. We can't deliver our judgment or even conclude the hearing, apparently. From the looks of you, I mean, your appearances and your expressions, it cannot be disposed of. So, not on 13. No, not on 13. Then
I don't think Mr. Sinha will take that long. I will definitely not.
13th is next month.
No, I'm talking about today. That if your lordships are gracious enough to give us that 1 hour.
I think so. No, 1 hour. We have barely 1 hour. No. We won't be able to complete the hearing, and we are confident of that. You mean
with some
only one indulgence, if the when Lordship is taking it up, could be taken up and slightly up in top of the list.
peculiar luck. Previous occasion also it was adjourned for on similar ground. I had I was
Yes,
sitting in the
yes.
spot for the Chatterjee.
Yes, Your Lordship.
This is ill luck. Not on 13th. Then we are keeping it on when? Tell us.
Any day.
Any day.
Any day, Your Lordship.
Any day means
16th or Saturday also. Your Lordship has been.
no,
Better the Saturday you can do it. But
Saturday.
So
Weekdays he'll sit at home. Saturday he wants to come report. He has a strange
people who anyway, and since the regular bench is not sitting and it transpires that the matter may request some amount of hearing, let the matter stand adjourned till regular bench will sit on 30th of April. That will be too late for you.
Then with some temerity, my lord, on 30th, if it could get some precedence.
30th is a hearing day, otherwise.
Oh, this is order 41.
16th, Your Lordship is there.
नहीं दूसरा पे जाना
Let the matter be listed in the monthly list of May 2026 at the top of the order 41 list.
Beautiful.
Shall we fix করে দে order 41 list এর top এ দিয়ে দেবেন.
Very
much. এক ঘন্টা লাগে আপনার বেশি
And Mr. Chatterjee is leading me is appearing virtual. Yes,
yes, he's there. Yes, Mr. Chatterjee.
This was comments on the earlier what happens here we are now
Mr. Chatterjee, the voice is breaking. What is the matter about? Please repeat. The voice is breaking in the microphone. Good for?
I am in the good for your declaration that the sale deed not executed by the defendant number 3 and 4 in favor of defendant number 1 and 2 is not bad in me. Now, my lord, by ground, my lord, which the trial court has dismissed the suit, my lord, is only that I have other remedies to avail and seek for preemption. Now, my lord, the appeal court, my lord, affirms the said judgment saying that those in my lord, section 44 of the Transfer of Property Act.
The problem with the connectivity.
So, Chatterjee, there is some connectivity issue. I mean, if in the second appeal, we don't want to take the risk of missing out on anything. We are being very candid. I mean,
I understand.
We'll keep it in the list. We'll keep it in the list. You can take a chance on urgent mentioning it. No, since there are since learned counsel for the appellant, since the lead counsel for the appellant appears online, and but there are connectivity issues, let the matter stand urgent for the day. Not the
appellate service টানে
এরা কেউ থাকবে না দেখুন না
I am led by Mr. Probal.
we are adjourning till 13th. Take it up on 13th.
We are here not ready to
Yes, we are testing you, Mr. Kaur. Yes.
Not plaintiff, not is the
for the other side.
Also, Mr. Probal Mukherjee is appearing for the.
You are also there.
No, I'm not there, but.
You are not there. You are there. We can see you. We can hear you.
Lordship, I'm not the advocate on rebus.
What are you doing here? Then take a seat at the back.
Or your respondent, your Lordship, led by Mr. Probal Mukherjee.
We asked you whether you are appearing for the respondent, sir.
Yes, it is.
Yes. Yes.
But the plaintiff, my lord, is the appellant.
Where is Mr. Mukherjee?
He is in another court, your Lordship.
Yes, Mr. Kormakar, what is the matter?
Plaintiff, my lord, is the appellant before your Lordship in a suit for specific performance. The original defendant, my lord, died on 8th of my lord, September, 19th of June 2016.
Yes.
Original defendant, my lord, died on 19th of June 2016. And my lord, good, bad, indifferent, the heirs of my lord, the original defendant had filed an application praying for substitution of their names on my lord, 8th of September 2016.
The defendants filed that application.
Yes.
To save you from.
But whatever be the reason, my lord, that was filed.
Very well. Then.
Now, my lord, the court automatically recorded the suit has abated. I filed an application, my lord, for praying for, my lord, setting aside of that abatement, because actually there was no abatement because the substitution application was on record. Whoever might have filed, my lord, it was on record. Now, my lord, that has been rejected.
By saying what, that mere filing is not allowing.
I did not take steps.
What is the ground?
My lord, comes to the
Let us see the
impugned
order. Impugned.
Finally takes the memo, my lord.
What has been rejected?
Oh, order dated
My
59.
application.
59, 2025.
Yes.
59. That's.
My application praying for setting aside of the abatement. Because I say, my lord, the abatement never took place.
ও তো রয়েছে অলরেডি রেকর্ডে একটা পার্টিকুলারলি তো হলো
আটটা জজ সাহেব
এটা কে বোঝাবে পিথ এন্ড সাবস্টেন্স বড় কথা ইউজ করে
Lord, now the Honorable Supreme Court also says, my lord,
হ্যাঁ ঠিকই বলেছেন
now the Honorable Supreme Court also says, my lord, any party, if that substitution is on
there was
record.
never any bar. Let us see the reasoning.
Yes.
But if Mr. Mukherjee is not there, they'll be embarrassed.
Admission.
Let them be embarrassed. Let us see this order. We are embarrassed by this order. Yes.
Lord takes up, Lord, the
Considering the submission. The key ground is considering. States that within the limitation period they have filed. Mr. Mukherjee will never come in this matter.
It is name be recorded.
He is on his way, Your Lordship.
He will be on his legs there, even after that.
No, he is on his way, Your Lordship.
On his way. Let him come. Let us ask him. He has already been fair in one matter in the morning. This is the second. No cogent.
Even he's fair only, not like us.
Order. I don't have it.
Order passed under order. Their application was rejected.
No, their application was pending. That is still pending. That's on record.
How many days delay was there for setting aside?
No, but with time.
But application is filed within time.
Ridiculous. কি বলবো বলুন তো এসআইআর করা নেই এসআইআর তো করি জুডিশিয়াল জায়গায় আনতে হয়রান এটা প্রশ্ন
Hey, court is enough power to take a liberal view.
দেখারও কিছু নেই দেখিনি তবু যদি কোথাও গলতা থাকে মিস করে না the order is otherwise applicable order 2029
prayer to Lord set aside abatement if refused.
just check up
Yes.
আমি order 22
Lord, an order, Lord K, 43 1K.
What is the language just read?
Lord, an order under order 9, rule 9, refusing to set aside the abatement or dismissal. That's Lord.
No, ওটা তো applicable. And the language of 22(4) is on an application made in that behalf.
Yes.
Shall cause the does not specify to the plaintiff.
That is exactly what has been clarified also.
Need not be clarified. Needs to be clarified apparently. Yes. Now, is what do you have to say? Tell us first.
Lordship, in their application under Order 20 Rule 9, Your Lordship, there is no prayer for condemnation of delay, Your Lordship.
Where is the question of that?
And no,
they have filed an application for setting aside abatement,
Yes.
right? Now that application for setting aside abatement has been filed on the strength of your application, basically.
Yes, Your
Acha, let us see your application.
Right.
Very. Let us see your
So that is, my lord, at page 38 of, my lord, the injunction application.
The order 20 rule 9 application.
Yes, Mr. Mukherjee has come. Another opportunity for you to prove your grace. Let's recollect the facts first, then.
Yes, page. Lord, he has taken out two application. Lord, one is from Lord the addition of parties, Lord, the legal heirs of Lord the sole deceased defendant for whom Lord the suit had been recorded abated.
Yes.
But that application is not maintainable, first of all, before your lordship, because I am Lord, I'll assist your lordship with the judgment of this court.
That has not been decided by the
No, but that is not the application which Lord they have taken out. Second application is for an application for injunction. Now, so far as
an application, please to set aside the order of abatement dated such and such, and further be pleased to restore the suit.
But that is not on the basis of the appeal.
No, Mr. Mukherjee, you're confusing.
He has come against the order of refusal to set aside abatement. So the learned court has refused to.
Page 41 is the prayer.
Yes, but I know about that. But in connection with this, Lord, the appeal, Lord, rejecting his application under Order 22 Rule 9, Lord, he has come up before your lordship with a memo of appeal and two applications. One is an application for addition of party. The other is an application for injunction.
Yes.
Anyway, that's a different issue, but he has come against that order of the
This
trial.
of the appeal itself. You are
This
here.
is the order of the trial court.
Because
Not
why
beyond those-
I say this? Because
That is
in the
beyond the
event,
scope of the appeal itself.
so in the event your lordship allows Lord their application for addition of party, Lord, the entirety of the Lord
No,
the
no,
my
we are-
defense goes.
No, we are not.
Main order is
Exactly.
appeal.
That is the reason, Lord, I'm Lord,
the
disturbing
main
your
order.
lordship.
We are disposing of the appeal, Mr. Mukherjee.
Very well, Lord. Then your lordship will kindly, Lord.
The appeal itself, now you have filed within time an application for.
I filed, although I was not obliged to file, but somehow I
obliged
filed,
them by
Lord, and-
filing.
Yes.
And Order 20 Rule 4 says on an application being made, does not specify plaintiff or defendant.
But Lord, they did not adopt that application even. Even the learned judge has recorded in the order that
They
they
need not,
refused to
but
take.
the order of recording abatement was
Court is
bad.
not powerless. Court can consider that application.
That is there
Abatement
also.
is automatic. In the absence of Lord, an application, Lord, for filing a
Repeat that.
substitution.
Please repeat that.
Lord,
That is our
the
answer.
position, Lord, I cannot, Lord.
No, you cannot change the.
I
You would
cannot
not change the
change,
position.
Lord.
That much confidence we have on you. That's why we said this is your second opportunity this morning to
I
please
know,
come.
Lord, my client has, Lord, made the blunder of taking out that application. But before
This
your
is
lordship
Biswajit
also,
Bosu used to crack a joke. You remember, Mr. Mukherjee, that
my lord,
in such a situation, suit was abated. The defendant filed an application. That application was allowed. Abatement was set aside. Substitution done. Plaintiff challenged that.
now, Lord, the other point is, Lord, that with the Order 22 Rule 9 application, your lordship will not find that he has prayed for, Lord, in condonation of delay.
Very well. In the body of the petition, did
Lord,
he
that
give
your
the
lordship will
explanation?
see, Lord, the explanation is that
Anyway,
there was a learned
Is the
advocate,
explanation whether
but
it is
passed
there?
away.
Mr. Mukherjee will say that he substantially prayed for setting aside the order of abatement. That order of abatement was per se bad, especially bad. Bad because on that date an application was pending under Order 22 Rule 4. Without considering that, it was the order of abatement was passed. So therefore, in any event, that order is required to be recalled upon allowing your application. So therefore, in substance, I mean, we are here to do substantive
I know,
justice.
Lord, recording of abatement, Lord, your lordship's, Lord,
Recording abatement is not a judgment also, so you know that. So that order itself was bad. I mean, as Justice, my learned brother pointed out, that court is also not powerless, in fact, to recall its order. But court did not do
court
that.
was, Lord, informed by my client, Lord,
Informed.
the information under Order 22 Rule 10.
No, not
Kindly
only. If he
kindly
stopped
note
there, we
that.
could have understood. If he stopped there, we could have understood. That information was
That
given.
application, my argument will be it is akin to Lord, Order 22 Rule 10. It was Lord, an information, Lord, rather given to the court, Lord, about the death of a
So
deceased
then we are
person.
dismissing the appeal and just.
That will be my ultimate prayer.
Yes,
his rigid views should not be taken in the interest
that
of
was
justice.
not an intimation to the court for them to take an action based upon my intimation. Because I have said that he has died. You take steps.
Where
you
is
could
their
not-
prayer? Just show us that to stop Mr. Mukherjee from arguing
No,
further.
Lord,
Show their prayer.
Lord, kindly comes to page 26 of my
Their application's
their
prayer.
application, yes.
Either to stop him or stop us. Because if that prayer is not there, then you are gone.
Hence, it is prayed for please to pass necessary order for substitution of the persons mentioned in paragraph number 4. Page 28, Lord, of my application, Lord, for Can 1.
Page
No, we are asking for the prayer. Prayer.
Yeah, it's page
Yeah.
28.
It is not the prayer.
কোনটা থেকে
It is at
দেখাচ্ছিস
page
দেখ?
31.
কোনটা থেকে দেখাচ্ছিস?
The can number. Lord, the addition of party application. They have prayed for substitution.
Hey, page 31 of our copy.
Oh,
Oh,
the other
maybe you are looking at the other application.
Page 31.
ওরা চেয়েছিল within pending ছিল the substitution application. Also rule 4 করছে on an application being made court will. An application was made, court did not record it.
Put it forward as per that section and 150. Consider instead of finding out technicalities.
Mr. Mukherjee, we are disposing of the appeal. In view of the short point involved, upon
No,
notice.
only consider, my Lord, the that whether they have made out any case for the delay in their application.
We'll record that argument of yours.
It will kindly.
There is no abatement on
The present appeal arises under peculiar circumstances. First up, in a suit filed by the plaintiff stroke appellant.
No, I'm substituting for him, Milord.
There's no abatement.
Plaintiff stroke appellant, comma, the defendants stroke respondents filed an application for substitution of the heirs and legal representatives of the. He was a sole original plaintiff.
No,
No, sole now.
Plaintiff is a company.
Original
And dependent is a sole.
Sole dependent. Sole dependent.
Acha.
Sole Alhaj Abdul Karim.
It was the sole defendant.
Sole defendant.
Oh, acha, defendants na. It কেটে দাও. The present appeal arises under peculiar circumstances. In a suit filed by the plaintiff stroke appellant, comma, the present respondents, comma, who are the heirs and legal representatives of the sole original defendant, Alhaj Abdul Karim, comma, upon the demise of the said defendant, comma, took out an application for substitution of the present respondents in place and stead of the said deceased as his heirs. Full stop. Next para. While such application was on record, comma, the learned trial judge, comma, nonetheless, comma, recorded that the suit had abated. Full stop. Subsequently, an application was made by the plaintiff stroke appellant for recall of the said order dated August 10, 2017, whereby abatement of the suit was recorded. By the present impugned order, comma, the learned trial judge dismissed such application upon the observation that despite having received information about the death of the defendant, comma, the plaintiff did not file any application for substitution and or for setting aside abatement, and Slokot did not even show cause as to the delay in filing the current application for recalling such order. Next para, learned senior counsel appearing for the appellant submits that in view of the pendency of the substitution application filed by the defendant at the relevant point of time, comma, the learned trial judge acted without jurisdiction in recording abatement of the suit without allowing the said application first. As such, comma, in any event, comma, the order recording abatement was bad in law. Next para. Secondly, comma, it is argued that in view of the application of the defendant for substitution, comma, and since the Code of Civil Procedure does not specifically debar even a defendant from filing such an application, comma, there was no further necessity for the plaintiff stroke appellant to file any application for substitution. Full stop. Next para, learned senior counsel, in view of the arguable questions involved, comma, we admit the appeal to be heard on the above questions and put the parties on notice that the appeal itself is being decided on the brief issue involved. Full stop. Next para, learned senior counsel appearing for the respondents counters the argument of the appellant and contends that the plaintiff, comma, who was the dominus litis, comma, had the onus to take out an application for substitution of the heirs and legal representatives of the deceased sole defendant. Full stop. Having not done so, comma, nor having furnished any explanation for the delay in making the application for setting aside abatement, comma, the learned trial judge was justified in rejecting such application. Full stop. Next para, however, comma, we are unable to accept the contention of the respondent for the simple reason that Order 22, Rule 4 is couched in such language that no restriction is created for the party who is to file an application for substitution under the said provision. Full stop. The language used in Rule 4 within bracket 1 of Order 22 is that double inverted এর মধ্যে the court C capital, comma, on an application made in that behalf, comma, shall cause the legal representative of the deceased defendant to be made a party and shall proceed with the suit, double inverted close, full stop. Next para, thus, comma, there is no restriction as to whether the plaintiff alone can file such an application in view of the language of the provision itself. Full stop. Next para, in the present case, comma, since an application was already filed by the present respondents, comma, being the heirs and legal representatives of the deceased sole defendant, comma, for their own substitution in place of the said deceased, comma, which was filed within the statutory limitation period as contemplated for filing substitution applications, comma, it was the incumbent duty of the learned trial judge to proceed in terms of Order 22 Rule 4 within bracket 1 and on such application having already been made, comma, to cause the legal representatives of the deceased defendant to be made a party and to proceed with the suit of its own. Full stop. Next para, hence, comma, the mere non-filing of an application for substitution by the plaintiff is merely an academic and redundant issue. Full stop. Next para, having not done so, comma, in any event, comma, the order dated August 10, 2017, whereby abatement was recorded despite pendency of the substitution application filed within time by the present respondents, comma, the learned trial judge had ample power and the incumbent duty to recall such order and to proceed with the suit by causing the legal representatives of the deceased original defendant, that is the present respondents, to be impleaded in the suit and to hear out the suit. Full stop. Next para, hence, comma, the impugned order suffers from error of law, patent error of law. Full stop. Accordingly, FMAT 8 of 2026 is allowed on contest, thereby setting aside the impugned order dated September 15, 2025, passed by the learned civil judge, senior division, 10th court at Alipur, district South 24 Parganas, in miscellaneous case number 164 of 2018, comma, arising out of title suit number 1089 of 2010, and directing the present respondents to be impleaded as party defendants to the aforesaid suit. Full stop. Next para, the learned trial judge shall proceed thereafter to decide the suit in accordance with law. Can one and
one is not an addition of party of not the present respondents, and two is an injunction that is being sought for.
In view of the disposal of the appeal, comma, can 1 of 2026 and can 2 of 2026 are rendered infructuous and are accordingly disposed of. We are not allowing or dismissing those. প্রথমেই affidavit size file to be given.
And I am also not taking the point of impleading not my client in the memo of appeal.
What?
a memo of appeal,
Yes.
Lord, the substituted parties have Lord already been Lord arraigned as a party respondent.
Yes.
Now that's on the death of the
So, Lord,
we had to
already
do it.
Lord they have.
Had to
No,
do it.
Lord, there
On
is
the
a
death of. That's how it's been done.
Otherwise, service
Yeah.
would be difficult.
Difficult.
the leave has to be taken. Lord. That's a technical
Yes.
point.
Yes,
Lord.
you are right.
Without hearing the years, how can we decide?
For that, Lord, they have to take out an application for leave, Lord, to proceed against the heirs of Lord the parties. But kindly, Lord, I'm not taking these points, Lord. No problem, Lord.
We are going to
Client
correct
has allowed
that.
an application.
We are going to correct that.
Not-
As rightly submitted.
It is my client who has assisted them. Lord.
Yes, that is true.
No,
And I
ওটা
agree.
দিয়ে দেবো ওদের।
That
একটু
Mr.
defect থাক যদি Supreme Court একটু defect।
Simple thing of Order
That
22,
Mr.
Rule 10A has been
Assistant as Miller, it's absolutely true.
not me, my client. He has taken out the application on your behalf. Much obliged.
Item number 79.
79, my lord, I appear for the appellant, my lord. The plaintiff is the appellant herein in a suit for declaration and cancellation of a gift deed dated 4th November 2024, my lord.
4th November 2024, all right.
Yes, my lord, the plaintiff is the father and and the respondent is the daughter of the appellant.
You executed a deed in favor of your daughter.
Yes, gift deed in favor of the respondent, my lord.
She did
Now
not
I
proceed
seek
under
the-
that Senior Citizen Act.
Yes, my lord, I have filed a suit. Now, why I have filed a suit, my lord?
No, Senior Citizen Act, it's limited in
Yes, well, the
some
Supreme
respect.
Court has already given, or I have the order. Supreme
What
Court
does it
order,
say?
that it can be cancelled. Gift deed can be cancelled if
Gift deed can be cancelled under the Act.
if the daughter fails to take care of the
That is under
parents.
the Act itself.
Yes, my lord. That has been affirmed in the Supreme Court decision of Urmila Dixit to 2025-2.
No, the statute itself gives that liberty.
There was some discrepancy when that has been
Eviction, there is some, we have some doubts.
Not-
Eviction, we have some doubt. Cancellation is contemplated in the statute itself.
That is
Maybe it has been held here that even if that is not specifically mentioned in the deed.
yes. Even if it not mentioned
That
in the
is
deed,
correct also.
yes.
Because if you otherwise, most of the orders we find that these are administrative people. So they what they do, because you plead, it's granted. But you have to at least prove prima facie that from circumstances or by oral evidence even or affidavit.
Yes.
That was the understanding. It need not be there in the deed itself.
Yes.
But yes, anyway, what has happened here?
But I had filed an Order 39 Rule 1 application, my lord, that was rejected on 9th of February 2026. That is the impugned order. Now,
What did you seek there?
I seek that the nature and character of the property should not be changed.
Why refused?
It was refused. My lord, why? Because I had to come clean, my lord. An order of injunction has already been obtained by a third party whom she has failed. The respondent has sold to some other third party. On 28 December 2025, she has sold the same to one Modern Sara Projects. I have taken out an appeal against that also. That is also pending. FMET 118 of
Have you
2026.
imputed that party?
That is not in this appeal. Not in this appeal. That is, he is not.
Not a
made
party in the suit.
Not in this suit, but I have taken a appeal against. In that suit, I have been made a party, and that I have made an appeal also. That is also pending. FMET 118 of 2026.
Before
this court.
Is it in the list?
It is not in the list. Not today.
That to appear along with this.
That
Otherwise,
but
you
may I
indicate-
just place the case for 5 minutes? Only 5 minutes.
Yes, that's why
Only
not.
5 minutes. But what has happened? The property, the suit property is a residential flat that belonged to the father of the plaintiff. There, after the death of the father, probate proceedings was initiated, and thereafter it gone to the mother of the plaintiff, Srimati Bijali Sarkar. And the probate was granted on 16 January 2018. It was granted to the mother of the plaintiff. Thereafter, the mother of the plaintiff, before obtaining the probate on 16 January 2018, she had already executed a registered will in favor of the respondent, daughter of the plaintiff. On 2017, the registered will was done. Very well. Thereafter, after the death of the plaintiff's mother, the Srimati Bijali Sarkar, the respondent, without taking a probate or applying for probate, she has approached this plaintiff to give the gift deed in her favor. Now, believing in her representation, the plaintiff has given the gift deed to the respondent. But the problem is, one of the heirs was still alive and is still alive. He resides in America. Now, without his presence, the gift deed is completely bad.
You are stopped.
Yes, Manoj.
You are stopped by your conduct.
Yes, I understand.
You are stopped.
That is why I'm coming clean and I'm stating all the facts. But I had stated that the plaintiff have one brother, Priyabrata Sarkar, and one sister, Krishna Katua. So, I'm sorry, the sister is still alive. Krishna Katua, who is living abroad for 20 years. Now the sister is alive. The brother's whole family has died. Brother's wife and daughter all have died. The sister is still alive. Now, as the sister is still alive, I am saying
the other appeal to appear along with this.
Yes.
To be heard along with this.
Yes.
And please, on the next occasion, just whatever you are submitting, either in the form of a list of dates or in the form of a genealogical table, just
to make it a short
it
list
will
of
be
dates.
easier for us because
Yes,
we are,
because there are a lot of documents.
I find it difficult to retain whatever you are saying, particularly at the end of the day. So everything there may be a confusion.
No, very well. I'll make a chart. I'll make
correct the defect. The appeal needs to be classified in words at its head.
It's not kindly granted to leave. I'll do that. Do it right now.
You are on record.
I'm the advocate on record.
Leave is granted to the learned advocate on record for the appellant to rectify the memorandum of appeal by giving the correct classification of the appeal in words and by removing the redundant caption. Please correct these things. This caption is also, it's not like memorandum of appeal from original order should be at the top. This should go there.
My mistake. My mistake. I should rectify.
If you know, then you do. Otherwise, ask somebody and do.
No, I know that.
You should know if you're doing so many things.
I do this.
Why did you do this? Somebody else
copy
drafted?
paste.
You will get a ear pulling someday.
Understand. I apologize. Now, kindly also direct that that appeal be tagged along.
Yes. What is the number?
FMAT 118 of 2026. 118 of 2026.
Any connected application?
Yes, Can 1 of 2026.
যেটা বললাম তারপরে let FMAT 118 of 2026 along with the connected application, comma, which have some identity of issues with the present appeal, comma, be listed along with the present appeal under the same heading on May 5, 2026. The regular bench will not be there before that. No, we can keep it next week.
Yes, that is what I'm saying. 16th, my lord. I'll do the matter.
Very well. তাহলে ডেটটা যেটা বললাম নেক্সট ইয়েটা on April 16, 2026.
Deeply obliged, my lord.
I will not be there in Andaman, but some bench will be there. So if it's an urgent matter, you can mention before the appropriate.
My lord would not be there then.
No, it will be in the list. It will be better for you if I am not there.
No. It will not be better. It will not be better, my lord.
No, in this matter, yes. Yes.
Thank you, Your Lordship.
No caveat? You are responding. Go.
The Lordship directed me to apply because there was an application for condemnation of delay, and my lord, another application that was, my lord, for substitution, which appellant has taken out on the last occasion.
What is the delay? Span of
Delay is, my lord, how
not much.
32. I am not standing on the with regard to delay.
No, but they are standing and they are moving
not-
the application. And substitution, what is your take on this substitution?
Substitution application which they have taken out in, my lord, indicating that the appellant has died during the pendency of this appeal.
That application is before us?
That application is appearing before your lordship. And your lordship, on the last occasion, I directed those 3 applications to be served upon me. My lord, I have received those.
If none appears for the appellant, what can be done? Although the respondent is represented through counsel, comma, none appears for the appellant at the time of call. Accordingly, let the matter stand adjourned for the day. না মুভ করলে প্রবলেম করে আগে
I'm grateful.
আগে ছোট করে বলে লেটেস্ট পজিশন পাইছে Yes, all of you are of the same surname. It is not allowed. 2 judges are allowed to have the same surname in the same bench, which the regular bench has.
Lordship, kindly, my lord, that is, it is required to be done today.
No, move the matter.
But your lordship, the last occasion, my lord, directed me to sub-copy upon the
What about copy?
substituted.
Not been served?
Yes, all of them duly received.
Move the matter.
227.
What does it arise from?
This is my application for substitution.
So why before us?
First step.
Civil division.
No, it is dismissed in Logima by the Honorable Division Bench.
Logima. What happened at the Logima?
But
due to
Rule was issued.
the case was abated, my lord. That was the finding of the Honorable Division Bench. I have annexed the copy of the order passed by the Honorable Division Bench. Paragraph 9 onwards, my lord, I have shown the reason why I could not.
All the PMT has been served.
Yes, yes.
No, she has that. This
all
proposed substitute heirs you have served. All of them.
everybody, my lord. They have received that, my lord, excepting one, my lord, dear lordship.
Recalling.
Number 8 did not know.
ওটাতে abatement record করেছেন।
Abatement record করে dismiss করে দিয়েছে।
The abatement was recorded. Abatement record করে তো
Yes, yes.
abatement.
Lordship, kindly have a look to page.
Where are the heirs? What is the reason for the delay, Ms. Maiti?
My lord, Ayesha, Mr. Ayesha Khatun died, and her,
What is the reason for the delay?
my lord,
What is the reason for the delay in filing this application?
delayed the
Reason for that.
Before your lordship was not aware that somebody, if, after death of this lady, an advocate for on her behalf should be informed, my lord. That is why they could not. This was the ground, my lord. I have taken paragraph 90 onwards, my lord. I have taken.
No, petitioner was not aware regarding the death of opposite party number 2.
Later on, he came to know.
Question is, it is the death of opposite party number 2.
Opposite party number 2 had
Which
died.
the petitioner was not aware.
Petitioner was not aware for some time, but later on.
As you have stated in paragraph 8.
Yes, your lordship.
Thereafter, from paragraph 9, you become aware.
Yes, later on, I went to the office of the learned advocate to take information. And at that time, I come to know that after taking searching, that has been dismissed for abated.
Abated and dismissed.
No step was taken.
81 বছর চাষি।
This is the 8 and 9 paragraph 8 and 9.
Despite service, none appears for the proposed added parties. Opposite party number 1 also you have served.
Yes, only one, my lord, that is proposed.
One is not proposed.
My lord.
One is the main PMT.
Yes, he has been served, my lord.
As well as যার বললাম সেই সেন্টেন্সে কন্টিনিউ করো, as well as opposite party number 1 PMT. Full stop, next para, the affidavit of service filed to be kept on record. Full stop. It transpired from the explanation furnished in the application that due to the lack of knowledge of the demise of the original opposite party number 2 on the part of the petitioner, comma, the application could not be filed in time, comma, resulting in the connected civil divisional application being recorded to have abated on August 13, 2021 by the order dated August 13, 2021. For the next para, upon hearing learned counsel for the petitioner as well as perusal of the materials on record, this court is satisfied that sufficient explanation has been furnished for the delay in preferring the application. 15 years, 1 month.
My lord.
Only. So you are not 81 when the thing happened. You're much younger.
Actually, I am instructed by this way, my lord.
Accordingly, can 1 of 2025 is allowed, comma, thereby recalling the order dated August 13, 2021, passed in CR 3 of 2009 in CO 3651 of 2008 and restoring the said rule as well as the revisional application to their original file and number. Full stop. Liberty to the petitioner to mention the matter before the appropriate learned single judge having determination to take up revisional applications. On orders to cost করে দেন. Yes.
Seven 98, my lord. 97 is my appeal, my lord, arising out of a decree.
My lord, I'm appealing for the respondent in 97 and the appellant in 98, my lord.
No, so there's some defects, Mr. Mukhopadhyay. One is Both are barred by limitation. It's
No,
the
we have filed CAN applications for
Can is there.
condonation. That's already there,
Court
Mullah.
fees,
Court fees already paid, Mullah.
30 rupees not paid in FAT 184.
Grant me leave, Mullah. No, 184 is not mine.
And, and 30 rupees in 107.
My lord, I
I could
undertake
not
to
escape.
undertake to pay my
Mullah, kindly
Both.
records are under.
And in 184, yours is 184. Bereft of name of presiding judge, trial judge. Name has to be given. Ask your counterpart in the trial court and put in the name.
My lord will do that.
Cure the appeals. Cure the defects.
We'll cure the defects, Mullah.
What is the application about?
Yes,
there are two applications in my.
whoever Mullah takes up first.
Collusion is very patent.
No. There's actually no collusion here. Mullah. Actually, no collusion.
What is the matter?
Now, Mullah, this is a decree that's been passed. I appear for the society, Mullah. The Society for Maintenance of our Immovable Property. A decree or other suit was filed by my learned senior friend for the plaintiff.
Found by a trust.
No, my lord. Akin to a maintenance society, my lord, for any complex, my lord, a building complex. Yes. So, my lord, suit filed by my learned friends who are owners or other, who are in possession and occupying shop rooms at the ground floor of that premises, my lord. Now, the articles of association of the trust and the rules of the, I'm sorry, not the trust, the society, my lord, provide that the shop owners will not be entitled to participate in any annual general meetings and also not vote. This is a society that's been there for decades, my lord, from the 1980s.
Other residential owners.
Yes, of course.
There's a divide between the two as per the article.
Yes, as per the articles. Now, the challenge in the suit is to the articles themselves, number one. Number two, also, they allege that we've been recovering excess amounts from them on account of maintenance as well as electricity.
They are challenging the
It's
article.
their suit. It's their suit. It's a suit by a shop owner challenging my articles and other management and affairs of the society.
They are members of the society.
They are members of the society, but without a right to vote, because that's the only thing. That's the sum and substance of the suit. Now, Mullah, on the appeal, Mullah will hear out the two applications. I have challenged. I'm sorry. I must indicate what the decree is.
Yes.
First. The decree has been passed, Mullah, partly in favor of my learned senior friend, partly disallowed. I am challenging the substantive portion of the decree which has been allowed in my learned friend's favor.
The articles have been changed.
Yes, has been directed to be changed.
And their prayer for this excess rent was refused.
That has also been allowed to a degree.
It has, my lord, if I may indicate, my lord, it has been allowed. The issues are
to an extent.
To an extent.
My lord, the issues are allowed in our favor, but my lord, the rate was not reduced in the decree. My lord, we are challenging to that extent, my lord.
You sought for reduction of the rates
my
of
lord,
rent.
reduction of the, my lord. My lord, if I may indicate, my lord, there are two, my lord, meanwhile, after passing of the decree, the office bearers of the society has changed, my lord. The president, chairman, and they are the parties in the main proceeding, my lord. A substitution is required to be carried out, my lord. We have taken out appropriate application to that effect.
No, the main suit is disposed of.
Yes, it's been decreed.
Disposed of.
This is a decree.
Has been
Mullah,
decreed,
from
my
all of
lord.
us.
Subsequently, the office bearers have changed, my lord. The decree has been passed in the name
Yes, so
of
you have filed an application here to change.
my lord. In
your appeal.
Here, in my appeal, my lord.
In my appeal.
That is one of the applications.
My lord, that is one of the application, my lord. Is CAN 2.
What is CAN 1?
My lord, CAN 1 is my is for condonation of delay. Is my section.
My CAN 1 is also for condonation of
What are the delays respectively?
Mullah, condonation of delay in my application 48 days. It was filed in
yours is?
Mine is 430 days, my lord. My lord, the petitioner was severely ill.
After deducting their time, you will have to explain the rest.
My lord was severely ill and she was admitted.
Advocate
in
was
hospital,
ill?
my lord. No, the petitioner. The
Petitioner
appellant.
was ill.
The
Only one
appellant.
petitioner.
Only one petitioner, my lord. She's a 83-year-old lady, my lord. She was admitted in.
And yours, Mr. Mpati,
I have two appellants, my lord, who are the society, office bearers of the society.
Your explanation?
Change korte hobe na.
I'm sorry, my lord. My explanation, my lord, it took time to collate the documents. My lord, will kindly see the
We are allowing both the
governments.
condonation
Yes,
applications.
My lord.
and also COVID, my lord, we've
My
had
lord,
some.
in their appeal, the substitution in my
Yes, that's
understanding,
not been
substitution
done.
is required to be carried out, my
My
lord.
lord, will grant me leave, my lord, the present incumbents will incorporate into the cost title if my lord kindly
The
grants us.
application we are allowing in respect of your appeal,
My lord.
and in their appeal, we are consequentially allowing on their oral prayer.
My lord.
Because it's virtually order 20 to 10.
My
So,
lord.
no, 20 to 9 bar is not there.
My lord, as to CAN 2, may I just indicate the other CAN that is there? CAN
Yes.
2 is for stay in my
No,
appeal.
first let us do this.
My
What you said. What are the CAN? One in both.
No, one is condonation of delay in my appeal, that is 107.
CAN 1.
One in both.
One in
Condonation.
One in
Well, let us allow CAN. Both yours is of 22 and yours is of 23. CANs also. CANs correspond to the years of the appeal.
Mine is for 23, my lord. CAN 1 of 2023. If it
Your
is
appeal is 180. Right.
Yes.
Very well. CAN 1 of 2023 in FAT 184 of 2023 as well as can 1 of 2022 in FAT 107 of 2022 are applications for condonation of delay in preferring the said respective appeals. For sub next para, upon perusal of can 1 of 2023 of can 1 of 2023, comma, we find that the appeal could not be filed within time due to the ailment of the uh, appellant, comma, who is an octogenarian, and as such find that sufficient explanation has been furnished for the delay. Accordingly, can 1 of 2023 is allowed, comma, thereby condoning the delay in preferring FAT 184 of 2023. The appeal be registered, be deemed to stand registered and admitted accordingly. Next para, insofar as can 1 of 2022 in FAT 107 of 2022 is concerned, comma, we also find that sufficient explanation for the delay in movement of files and taking decisions has been explained. Accordingly, can 1 of 2022 is also allowed, thereby condoning the delay in preferring FAT 107 of 2022, and the said appeal is also deemed to stand registered and admitted. No arrest to costs in either of the applications. Next, now can 2, what is your can 2 and what is your can?
Mine can, should I place mine first?
Oh, no, the other application has to be that first.
My lord, can 3 in FAT 184 of 2023.
Can 3 in FAT 184 of 2023 is an application for substitution, comma, within the contemplation of Order 22, Rule 10 of the Code of Civil Procedure, comma, of the present incumbents of the respondent societies. Next para, correspondingly, comma, even although there is no specific application on behalf of the appellants in FAT 107 of 2022 to that effect, comma, learned counsel appearing for the appellant in the latter appeal, in the said appeals, also makes similar prayers. Since substantially the relief sought by both parties in respect of their respective appeals is the same, comma, we allow can 2 of 2022 as well as the verbal prayer of the appellant in FAT. Sorry, that is 23. It should be.
My lord, can 3 of 2023.
Sorry, can we allow can 3 of 2023 and also the similar verbal prayer made by the appellant in FAT 107 of 2022 and direct the current incumbents of the society in question to be implemented as parties in place of their predecessors in office in both the appeals. The necessary corrections, consequential corrections to the memoranda of the said appeals shall be carried out by the learned advocate on record for each of the parties in the appeals by tomorrow.
Madam.
Yes.
Right.
Now, your can 2 and your can.
Yes, Malad, I don't know. I'll just indicate what the matter is, or rather why I'm seeking stay of operation of this decree, Malad. Here, the decree has been passed, Malad. No courts are reluctant, civil courts are reluctant to interfere in management and affairs of societies unless there is shown to be, Malad, express violation of principles of natural justice or arbitrariness. It's a high standard. Here,
More than that, here if you stay, the effect will be the appeal is allowed before.
That is
Because
why I don't.
the articles get
I
restored.
fully understand. I fully understand. What I'm only submitting, Mullah, this is on instruction. The difficulty we're facing, I'll just canvas before, Mullah. There is an observation in the trial court's decree, Mullah, whereby, Mullah, what has happened was maintenance charges are payable as in respect of all the members of the association as per the square footage. We charge a particular square footage as to maintenance charges. This is for maintenance. This is a non-profit organization just for maintenance of that property. What the appellant, or rather plaintiff before Mullah has done, they have created a mezzanine floor in their shop room, thereby increasing the square footage. That is recorded also in the trial court's decree, but the trial court has said that the maintenance charges will be paid as per what is payable by every single other member. So I understand that this is open for interpretation. This is open for interpretation. If Malad will kindly clarify, since Malad is in season of the appeals and the appeals are now alive, I understand, Malad, but then they're not paying what has been directed by the trial court. They have not paid what has been directed by the trial court itself. I'll just indicate one page and thereafter, Malad, I'll leave it up. That's all. I'm only saying this is the trial court's decree has said they have to pay as per what the other members are
Your
paying.
application, you have asked for stay of operation of the decree.
I
And
understand.
you are
But
insisting
Malad,
that they pay in terms of the direction of the trial.
I am saying, Malad, let
to
them.
understand the dichotomy in
I
that.
understand. That's why I don't want to really say much on it.
We
I am
can
only
do that
saying,
in their application. Let us see the scope of their application. We can put it as a condition.
Malad, let that be done.
If you are
And
satisfied.
I understand, Malad.
Lord,
And Malad will
now
kindly
speak.
hear out the appeals if it commences to Malad as expeditiously as possible. I can only pray after amendment.
My lord, kindly fix us any day, my lord. Will take.
What is your application?
My lord, is my application for injunction in as much as, my lord, they are raising electricity bill in much excess of what CSC is charging, my lord. My lord, for instance, my lord, CSC is charging 9 rupees
We'll direct
per unit,
affidavits
my
on
lord.
that application. We'll direct affidavits on that
My lord.
application. In that application, you can make your allegations regarding them not paying and what.
My lord will do.
My lord, we are
My lord
duly,
will
my, as far my instruction goes,
This
we are
requires
duly
affidavit.
paying the electricity.
This requires affidavit is because
My
their
lord.
version has to come on record also.
On instruction, I might just indicate, my lord, my instructions are we are not charging them in excess of what is being charged by you, not a single
If
paise.
you say they are charging, we need not advise you. You are sufficiently, both of you are sufficiently, all of you are sufficiently competent. You put in the materials which in support of your amendments in the application. If necessary, you can do that in a supplementary affidavit. You must have annexed something in your
My
application.
lord, we have annexed, my lord. If my lord directs, please to
No, we
direct
don't
for filing of.
direct. If you want, you can.
So
But do
opposition
that right now.
Yes, yes. My lord, we'll file an affidavit, my lord.
We'll file our
No,
pleadings.
no, opposition reply will direct.
My lord.
Is your application sufficient to disclose?
My lord is coming after a long time, my lord. I need to peruse it once, my lord. My lord, he kindly grants me leave if required, my lord. We'll file.
No. So many annexures.
My lord,
All
old bills are there.
Those
as
are
I
all
can-
bills. There's nothing.
All bills, my lord.
New bills are not there. Your allegation is on the
My
new
lord,
bills.
is still 2023. I have
Not
filed
latest
appeal.
state, current bills after decree. You are saying they are charging. Present tense.
No, new bills are not there.
I need to advise you on that.
My lord, I need to. It's coming after a long time, my lord. I'll need to take some instruction.
আমরাই বসে সেটাও আমাদেরই করতে হবে অ্যাডমিনিস্ট্রেটর বসলে আপনাকে আমাকে কি করতে হবে স্পেশাল অফিসার হলেই এরা পক্ষই একদম অবজেকশন দেবে না একদমই দেবে না ওদের ক্লায়েন্টরা দেবে না ছেড়ে দিন অপোজিশন ডিরেক্ট করে ছেড়ে দিচ্ছি অন দি প্রেয়ার অফ ল্যান্ড কাউন্সিল ফর দি অ্যাপেলেন্ট ইন FAT 1 yours is 184 FAT 184 of 2023 comma we grant leave to the appellant to file a supplemented affidavit to Can 2 of 2023 within a week from date, within a fortnight from date. Full stop. A copy thereof shall be served in advance on the learned advocate on record for the appellant in FAT 107 of 2022. Full stop. Next para. A composite affidavit in opposition to TO2 Can 2 of 2023 as well as the connected supplemented affidavit shall be filed by the respondents in FAT 184 of 2023 within bracket appellants in FAT 107 of 2022 within 3 weeks thereafter. Full stop. Reply if any 3 weeks or fortnight.
3 weeks.
3 weeks thereafter. Full stop. Reply if thereto, comma if any shall be given within a fortnight after such affidavit in opposition. After the timeline for the affidavit in opposition elapses, full stop. Next para, liberty to the parties to mention the application for inclusion in the list as and when the timeline for filing affidavits is over. Full stop. In view of the all the parties are represented.
Yes.
In view of the appearance, all the parties, comma service of notice of both the appeals on the respondents is dispensed with. Full stop. The trial court records shall be called for by special messenger. Who shall pay this special messenger costs?
Whatever.
You are the associate, you will pay.
Well, they are not paying. They should ideally pay.
Then split the special messenger cost. You will pay 15 rupees and you will pay 15.
Well,
the special messenger cost, no, then nobody will pay.
No,
the special messenger cost shall be
me to pay.
The special messenger, the trial court record shall be brought by special messenger at the cost of the appellant in FAT 107 of 2022, comma to be deposited within a fortnight from date. Full stop. Who will prepare the paper books? That's more costly.
I leave it up to
Whose appeal is prior? Your appeal
ours is prior. Ours is prior. And we have the urgency, because they're not paying.
The appellant in FAT 107 of 2022 shall prepare composite paper books for both the appeals within the requisite number of composite paper books for both the appeals within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant in FAT 107 of 2022, incorporating all the relevant documents. For such purpose, copies of the memorandum of appeal of FAT 184 of 2023 shall be served by the appellant therein to the learned advocate on record for the respondents therein within a week from date. Full stop. I think this. Oh, this much.
Malad, one further line, if it commences to Malad,
Yes.
nothing, the pendency of this appeal will not affect my right to recover whatever arrears if
We have not
otherwise.
listed into Malad. We
I
didn't want to
understand
create
Malad,
complications.
because they haven't been paying. Malad will kindly appreciate more than 4 lakhs is due as on date, even as per the trial court decree.
We
Not,
won't make any observation on
Malad, if an
that
appeal,
either way.
I understand. Malad,
Why
I'm
should
not
we
asking.
create an impediment?
Or else, Malad, if I file a suit, they'll take the point of pendency of the appeal. If Malad will kindly consider, that's our apprehension.
No.
Malad is keeping
One
it
extra unwarranted observations create more problems.
Malad is keeping it returnable after 8 weeks, Malad.
We are putting it out, taking it out of the list with liberty to
Liberty
application with liberty to you to mention it. The appeal directions we have already given.
Mine. Obliged.
উঠবো তো আচ্ছা 19 দেখেনি দেখি other matters are released whoever is sitting behind we are sorry we have another bench I have another bench actually
Application.
yes Mr. Bhattacharya quick
Yes, my lord. I am the appellant, my lord. The appeal was dismissed. My lord, there are 2 applications which I have filed. One is a restoration application, and my lord, another is my lord a transposition application. My lord directed my lord service of copies. My lord, we have served. Now, my lord, restoration, my lord, the matter was dismissed for default on 8th of November 2025.
substitution is also there
No, transposition.
restoration has to be allowed first
Yes, kindly see.
restoration is within time
My lord, from the application which they have served me, my lord, it is very difficult for me to ascertain, my lord, whether this application has been filed in time or not, my lord.
Yes.
There is no date.
11th November, filed on 16th December.
Fine.
Mr. Bhattacharya will not take it up like this
Next.
Take back the affidavit of service file the affidavit of service. Affidavit of service filed today be kept on record. Full stop. Would you like to make any supplementary affidavit? Is it necessary or you'll argue on this? Because she has taken the point.
No, it's there in the lordship's copy also.
However, due to paucity of time, the matter cannot be taken up today. Full stop. Accordingly, the same is adjourned for the day.
Sure. Not filing date.
Same is adjourned for the day.
16th December. It's filed on 16th December. I have the filing slip also.